Daily list for admission and then one.
Your Lordship, we find this appeal in section 42 of the PMLA Act, wherein we are challenging the impugned order passed by the Honorable Appellate Tribunal dated 13/8/2025, wherein the provisional attachment order was confirmed. If Your Lordship may, that I may just briefly summarize the facts, Your Lordship.
Yes,
Your Lordship, the appellant herein is the property, the concerned subject property is the dwelling house, the residential property of the appellant, which was attached emanating from the FIR proceedings, which is dated 17/1/2020. Herein, Your Lordship, there were several grounds that were taken before the appellate tribunal.
look, the offense in question was between 18 and 2020, correct?
Your Lordship, the notification was passed in the in 11/4/2018. Subsequently, there was another notification on 16/11/2019, and the examination took place in 2020. Therefore, the FIR was registered in 2020. Your Lordship.
So your case is that you purchased the property in June 2019.
No, Your Lordship, our case is that from 2008 onwards, we have been making payments towards the property. Till the year 2011, Your Lordship, we have completed payments. The appellant has made payments from the salary account of the appellant. Now, the appellant herein is a government employee who has been in service since 1995. Thereby, Your Lordship, he has also complied with the taxation implications out of it. Our case before the tribunal was that this property was purchased much prior, that is from 2008 to 2011, and the offense is 2020. And further, Your Lordship, there is a very settled proposition of the Honorable Apex Court, which has very clearly laid down that in such circumstances, where the property is purchased in prior, there is no relation and hence the same cannot be attached, Your Lord. My prayer today, Your Lordship, would be restricted to issuance of notice, though, Your Lordship, and admission for appeal, Your Lordship.
But the issue pertains to this proceeds of crime, correct? How it has to be defined.
Correct, Your Lordship.
And whether there can be two definitions or, two parts to it or three parts to it.
3 parts to it, yes, Your Lordship.
Then, doesn't it come in one of the parts?
Your Lordship, my pleaded case that it does not, at the tribunal has misinterpreted the provisions therein. That is section 21U, Your Lordship has rightly pointed out the exact section, that is section 21U. And Your Lordship, if we co-jointly read section 21U along with section 5, there are certain prerequisites that are to be fulfilled, which Your Lordship was not fulfilled at the stage of adjudicating authority. Hence, we had challenged the same, Your Lordship.
Yes, madam.
No, Lordship, there are 3 parts, the definition, and there is an
That has
order
been
in
held by the
between.
Supreme Court also.
Yes, Your Lordship, if Your Lordship may allow, then I can argue therein. But today I wanted to just restrict on issuance of
No,
notice, but I can
that
argue.
is the issue.
Correct, Your
There's
Lordship,
nothing
if
else.
required, I can argue it.
That is the only issue. The only issue is whether the definition under 21U
Yes, Your Lordship.
pertains to has 3 parts in it or there are 2 parts in it.
Right, Your Lordship.
I think you agree that there are 3 parts to it.
My case would be, Your Lordship, that there are 2 parts. There is an explanation which adds a 3 part to it. And it has been explained. Your Lordship, I will show precedence to that fact.
Just show. That's the. Miss Jane is also there.
Yes, Your Lordship, she was very kind enough to let a junior argue, Your Lordship.
Okay. Yes.
Sorry, I've just handed over the judgments. Your Lordship.
Okay.
Your Lordship, I'll take you through the provisions,
Yes.
the case law, and the effective portion which we are per se challenging.
Yes.
Now, your lordship may first refer to section 2, subsection 1, subsection U, proceeds of crime.
Para 12 of the judgment.
First, your lordship, I'm taking you through the exact provisions, and then
It's in para 2(1)(u).
2(1)U. Yes, your lordship.
I mean, it's in para 12 of the judgment.
Yes, para 12 of the law. So, your lordship, may I read it through?
Yes.
So, proceeds of crime means any property derived directly or indirectly by a person,
Yes.
by any person.
Yes, sir.
Yes, sir.
2(1)(u).
2(1)U.
2(1). This is at page 8. Yes.
It
Yes.
says proceeds of crime
Yes.
means any property derived or obtained directly or indirectly by any person as a result of a criminal activity relating to a scheduled offense.
Yes.
This, your lordship, is the first limb
Correct.
or value of any such property.
Correct.
Second limb, third limb, your lordship, or where such property is taken or held outside the country, then the property equivalent in value held within the country. Now, your lordship, there is an explanation to it, which reads that for removal of doubts, it is hereby clarified that proceeds of crime include property not only derived or obtained from a scheduled offense, but also property which may directly or indirectly be derived or obtained as a result of a criminal activity relatable to the scheduled offense. Your lordship, the cases that I would refer hereby, they very much stress on the portion of relatability with the offense, your lordship.
Now the impugned judgment that you are challenging, that has relied upon which limb of this 2(1)(u).
It has relied over equivalent in value, your lordship. That is,
In value.
yes, and if your lordship
Or
may,
do you mean the value of any property?
no, your lordship, the exact paragraph is the second last paragraph, which your lordship is in page. It's in page 318A of the appeal, your lordship.
318.
Para
Page?
16,
Page?
318A.
318E.
318A.
Last page.
Yes.
It says, your lordship, in the light of discussions made above and the judgments of the tribunal elaborately discussing the judgments of High Courts and Supreme Court. So the case that I would be referring is Pavana Dibur, which is passed by the Honorable Apex Court. It was placed.
There's a two judges bench.
Your lordship.
Two judges bench.
This, your lordship.
No, there's
The Supreme
Pavana.
Court case.
Yes.
Yes, your lordship.
Pavana.
It's a two judges bench. Your lordship.
Is there any three judges bench or something?
No, your lordship. Currently, there's no three judges bench. However, this actually a section 42 appeal is very rare circumstance. There are, as far as my research goes, it's around 40 to 50 cases around the country. So several high courts are still considering the same, and this is the first time it's before the Honorable Guwahati High. Yes, your lordship. Para 16, your lordship.
Yes.
So it says that we do not find, even if the proceeds of crime has been vanished, and is not available with the person accused, property equivalent value cannot be attached.
Yeah.
So they have relied upon equivalent value, your lordship.
Correct.
Which, your lordship, if we read it with 2(1)(u), it says that only when such property is taken or held outside the country. Now, your lordship, this is a particular property which is the residential property of the appellant. He's staying with his entire family, has been paying electricity dues since the year 2012. Payments were complete in 2008 and registration, your lordship, was in 2019, which the respondents had relied upon before the adjudicating authority. Registration, your lordship, is not per se only the duty of the appellant. It has to be also the duty of the builder here, your lordship. It cannot be.
Can it come under the second limb or the value of any such property?
I will take your lordship to the case law pertaining to that. First, your lordship, if I may take you through Pavana Dibur, which is the Supreme Court case. It is 2023 15 SCC 91.
Yes.
So, your lordship, first, this particular case is pertaining to whether a property purchased in prior can be attached or not. This particular case for, and then I would go into value, the second limb, as your lordship has rightly pointed out. The relevant paragraph, your lordship. First, the submissions is in para 7. So here, your lordship, in this case, there were several properties. In the Supreme Court case, there was 2 properties which was purchased in prior. There were 2 properties which was purchased when the appellant, the petitioner herein before the Supreme Court had enough money, and one after. So this case has discussed each and every segment to it. With regards to the prior, para 7, the learned senior counsel appearing for the appellant firstly submitted that the first and second properties are not tainted properties and therefore same not covered under the definition of proceeds of crime under clause U subsection 1 of section 2 PML. The senior counsel pointed out that the first property was acquired on 1/7/2013, much prior to the commission of the first schedule offence. The allegation in the FIR dated 11/11/2017 against the accused number 1 is that he collected a sum of about 107 crores from the accused between January and November 2017 and transferred to his account. Therefore, the appellant's acquisition of the first property can never be linked to the proceeds of crime regarding schedule of. Now, this is the pleaded case. Effective portion, your lordship, is in para 13. And further, your lordship, the last conclusion is in 19. So 13 says that clause V of subsection 1 of section 2 PMLA defines property to any property or assets or every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, to constitute any property as proceeds of crime. It must be derived, obtained directly or indirectly as a.
No, you're reading at para 13.
I'm reading para 13.
Yes.
So this definition part and the final observation, I'll point it out. It must be derived or obtained directly or indirectly by any person as a result of a.
You're reading that. It must be derived.
It's in para 13, your lordship. I'll read it again.
It must be derived. Oh, okay. Must be derived.
Must be, has your lordship found it?
Yes.
Must be derived or obtained directly or indirectly by any person as a result of a criminal activity relating to a scheduled offense. The explanation clarifies that the proceeds of crime include property not only derived or obtained from a scheduled offense, but also property which may directly or indirectly be derived or obtained as a result of a criminal activity. Clause U also clarifies that even the value of any such property will be proceeds of crime. Thus, the existence of proceeds of crime is sine non qua for the offense of section 3. This was discussed, your lordship. Hence, thereafter, finally, in para 19.
So prior to the purchase, there must be a crime.
Yes, your lordship. So,
There must be some criminal activity
Right,
prior
yeah.
to the purchase.
purchase.
That is your case.
That is my
That is the case.
before discussed. And then, your lordship, on para 19,
Yes.
it is the second last line of the paragraph.
Yeah.
It says the first property ex faci cannot be said to have any connection with the proceeds of crime. The acts constituting the scheduled offense.
19.
19, your lordship.
Second last line.
Second last line. So it the
Last line of the set paragraph.
second last line of the first.
Or the
My apologies.
of this page. Okay. The first property.
First property.
Yeah.
It says the first property ex faci cannot be said to have any connection with the proceeds of crime as the acts constituting the scheduled offense took place after its acquisition. This was clearly held by the Supreme Court. This has not been challenged. And as on date, even several high courts, that is the 2 other cases that I would be referring to, has relied on this particular property. Delhi and Kerala, your lordship. Now, with regards to your lordship's question of value thereof and equivalent in value, there are 2 cases that I'm referring to, your lordship here. First is Kerala High Court, which is very recent. It is 2024 SCC online. Kerala 7343. It is Devi Varghese and another versus ED. This also, your lordship, was placed before the tribunal. Your lordship, here the first paragraphs, that is still para 17, was with regards to the jurisdictional issue that I am not taking your lordship's to. Para 17 again discusses whether property prior can be attached and then goes on to explain value thereof and equivalent in value. So, Your Lordship, if I may take you to para 17 of Devi
Yes.
Verghese. It reads, the first three properties in the above table were conceitedly purchased by the petitioners in the year 1997, 1999, 1987, that is even before the PMLA Act was enacted. As seen from Exhibit P1, the period during which predicate offence is alleged to have been committed by the officers of the bank is between 2014 and 20. Hence, the property purchased by the petitioner cannot be treated as properties purchased using the proceeds of crime. This was discussed there by Your Lordship in para 20, 21, 22. The court has very clearly stated what is in value thereof, what is equivalent in value. I'll read it through, Your Lordship. Para 20.
Yes.
So para 20 first says, Section 5 of PMLA Act authorizes the attachment of proceeds of crime. The above extracted definition indicates that there can be three types of proceeds of crimes, which are firstly, property derived or obtained as a result of a criminal activity. Secondly, value of any such property. Thirdly, if the property is taken or held outside India, then a property equivalent in value within India. Now, Your Lordship, if you may recall, para 16 of the impugned order, it mentions equivalent in value. The order was passed on the understanding that this particular residential property of the appellant, there is either taken or held outside in India, which is completely contrary, Your Lordship. And then a property equivalent in value within India can be attached. Now, Your Lordship, the most effective part is para 21 of this case, which defines value thereof. It says, the definition of the term proceeds of crime explicitly states that when proceeds of crime is a property, such property must have been obtained or derived as a result of any criminal activity relating to a scheduled offence, which Your Lordship was also discussed in Pavana Dibut.
Paragraph?
Para 21, the subsequent paragraph.
Yes.
Has Your Lordship found it? So the first part was discussed also in Pavana Dibut, which is the Honorable Apex Court's judgment. Second part says, no doubt, even if property was obtained indirectly, it can still be regarded as proceeds of crime, assuming that a property derived out of a criminal activity mentioned is not available. Still, attachment can be effected to the extent of equivalent value of such property. The term value in section 2, subsection 1, subsection U can only mean the monetary worth of the property that was derived from that criminal activity. This is evident from the words value of any such property. The only method when a property which is unconnected with the proceeds of crime can be attached is when the property derived out of the criminal activity was taken out of India or is held outside the country. Under no other circumstance does the statute mandate the attaching a property unconnected to the proceeds of crime. Thereby, Your Lordship, it was in para 22, Devi Verghese has also relied on Pavana Dibut at the same time. And the next case, I would just, because this is also in relation to value thereof, so I would also show that it is a case of Andhra Pradesh High Court, which was passed in 2021. I will take Your Lordship directly to the concerned paragraph in that case.
Yes. Para.
Yes, sir. Para 24, Your Lordship. The earlier parts are again with regards to prior attachment. This para is again with regards to value and equivalent in there. Has Your Lordship found it? The division bench held that the property derived from the offence would be proceeds of crime, and any such property purchased or acquired before the commission of offence would not fall within the first limb of definition of proceeds of crime. It also held that if such property is moved abroad, any property of the accused available within India, irrespective of the date of acquisition, can be attached to proceeds of crime, as the same would fall within the third limb of the definition. Now, Your Lordship, in any case, in the attachment order, they have not stated that this property is moved outside India. This is not their case itself. However, the division bench held on the ambit of value of any such property, that this term is not the same term as property equivalent in value. It might be the case, Your Lordship, that the Honorable Appellate Tribunal wanted to go for the second limb. However, they have the findings are on the basis of the third limb, Your Lordship, which is equivalent in value.
If they had gone on the second limb, then
Even in that case, the definition clearly says what constitutes value. It is when it is sold off and the property is purchased out of that proceeds, Your Lordship. Now that has to be the case of the risk.
and no, the property need not be so from that.
It is here, Your Lordship. I'll
let
just
us-
read it
yes.
then in that case. The division bench, however, the division bench, have you found that line?
Yes.
Yeah. Held on the ambit of value of such property, that this term is not the same as property equivalent in value within the country or abroad, which appears on the third limb, and the same cannot be given to both the terms. While explaining the scope of the term value of such property, the division bench took the view that if some properties which are obtained by committing an offense and are sold prior to the registration of the FIR or ESIR, the money generated from the sale or transfer of such property in the form of cash or any other property which is available for attachment would answer the description of value of such property. Hence, Your Lordship, this was the case which we placed before the tribunal also.
A reading of 2-1U, now that second limb. Or the value of any such property. So a value of any such, you see, the third limb pertains to a property taken or
Outside of-
outside the country, that's different.
Yes, Your Lordship.
So why will the second limb not take care of the issue regarding the property that is within India?
Your Lordship, the offence, it is alleged that the appellant has been involved in an amount of 40 lakhs. The property in question is 16 lakhs, Your Lordship. Even in that case, the value is not equivalent in nature.
Correct, but it has the equivalent. They use the Madam, won't the second limb be applicable here? Otherwise, they will not be able to do anything unless it falls in terms of the third and first and third limb.
Your Lordship, there
Respondent.
has to be some relation with the offence.
It has to be.
Now, considering,
So all supposing supposing the offense on the basis of which you have made money is all outside India. Now, what is the scope for getting it back? And they cannot trace it. Now the only way out would be to a property of equal value. So they'll take that property and give you after auction, they'll give you back the remaining money.
Your Lordship, then in that case, it has to be recorded in the reasons of belief that there is a belief that this property or this amount has been siphoned off outside India, which is not the case of the
That doesn't have
respondent.
to be. Doesn't have to be. Maybe they've not been able to find it within India also. and they don't have any clue that it is outside India. Supposing they have not been able to trace out, but they know that they have siphoned out, then what happens?
Your Lordship, my pleaded case here would be to look at both the perspectives at the same time. First, that it's a property which is
We'll have to basically see that.
it makes sense. One case, one advantage.
Yeah. That is not property that is gonna. Maybe. I don't know from the court that I the 30, I think that. If we'd have to go to. Mostly. Otherwise, yes, madam, are you ready?
Yes, Lord.
Yeah. Acha, before you start, just a minute. Now let us see the decision, the impugned decision.
Impugned decision is from page 296 onwards of the opinion.
296.
Findings at page.
Findings are
That is the operative portion. You see, when you come to para 16 at page 318A,
yes, sir.
it says that we do not find that even if the proceeds of crime has been vanished and is not available with the person accused, properties of equivalent value cannot be attached. It does not speak of the property being taken outside.
It does not. Yes.
It's just that it has used the word equivalent. So that's why you have implied that it means he has gone to the third limb. But it could
You'll-
mean that this has been attached by applying the second limb.
Your Lordship, this particular observation is exactly connected with the provisional attachment order, which is recorded by the respondent authorities where they have relied in equivalent in value.
Maybe you see the use of the word equivalent may not be the clinching factor here, just because they have used the word equivalent. This equivalent value may also mean or the value of the property, value of. So they've just clarified it a little bit more. That's all. I mean, why
Yes.
it can come within the second limb.
Hence, Your Lordship, I had relied upon this particular judgment of the Andhra Pradesh High Court and Kerala High Court, which has defined what constitutes as value thereof. Also, yes, Your Lordship, it's an apex court judgment, but it does not explain the. Your Lordship, now I understand the question of Your Lordships. There is also another segment to it, Your Lordship. May just give me a minute.
Reason to suspect. This is page number 42 of the memo.
Your Lordship, may kindly. Your Lordship may kindly come to page 43 of the opinion.
843.
Yes. I, however, don't have a copy of this judgment, Your Lordship. However, when a particular reasons to believe which has to be satisfied under section 3 and
Page
section 5.
43, yes.
Yes. So just the pretext to this particular submission that I'm giving is that section 3 and section 5 says that there has to be a particular reason to believe. Now, this reason to believe has been defined in multiple cases of several high courts. It says about the operative portion we had given before the tribunal, I, however, don't have a copy of, Your Lordship. I'll just read it through in that case. Why I'm stressing upon it is on the factum of nexus, which is very essential, Your Lordship. Now, it says that the only safeguard that is available, as in Your Lordship is saying, for DED to recover. So, based on that, I'm citing this case. Only safeguard that is available to a person against indiscriminate seizure, which is a serious intrusion into the fundamental and legal rights of an individual, has been provided in the expression of reason to believe. What is the law on this point has been repeatedly dealt with and elucidated by the various high courts and the apex court in the judgments. it is a settled law that the power of seizure cannot be used as a roving and fishing inquiry. Reason to believe is not the same as reason to suspect. Because if such an interpretation was given, then no citizen would be safe, and reason to believe must exist prior to the seizure. And it is a thing that the acquired seizure, when the explanation of person is not found, is correct. Just one second. Abdullah case. If your lordship may again come to page 49. My apologies, your lordship. Page 50. Herein, the appellate tribunal have themselves stated the essence of a nexus. Operative portion is para 13 of this case with relation to section 2U of the Act. I'm just reading it through. Value of such defined under section 2ZB of the PMLA Act has to be harmoniously read with section 2U of the Act, which mandates to acquisition value to only situations where proceeds of crime being attached. Such application cannot be pedantically extended to situations where the property equivalent of alleged proceeds of crime are being attached, which do not have any nexus or continuum with the alleged direct proceeds of crime. Even in this case, with regards to equivalent in value, they are referring and they are relying upon the essence of a nexus being there with the proceeds of crime, which your lordship, they have not been able to establish even as on date.
Okay, let us hear. Yes.
Please, Your Lordship. Lordship, firstly, the total amount of process of crime is around 6 crore, out of which the petitioner has received 40 lakhs. 40 lakhs. And from there, only a part is attached, that is 16 lakhs. And Lordship, regarding
How can why should 60 lakhs be attached when only her share is 40 lakhs?
the other part assessment, that is vanished, Lordship. So because it is vanished, so otherwise, so that is the reason why this is available with the petitioner. So this, so this has been attached. And next, regarding Lordship, reasons of belief that was duly followed.
Yes.
So that's why property worth rupees 16 lakh 60,000, which is only a part of the value.
When was the property acquired?
That was the sale
Your lordship, I may take you through the
19, I think.
By you in 2019.
2019.
registration
Which was
was
during-
2000.
during the-
25 then from when are we going to accept the date that you are the ownership?
Lordship,
From the date of registration only.
from page 200 onwards. Your Lordship.
Can it be from the date of mutation?
Your lordship, the
Yes,
directions are very
finance,
clear
penalty report.
that it is from the date of purchase. Purchase receipts are from page 200 onwards.
2019.
Sorry, registration is 2019, your lordship.
Okay.
Payments are
Cases?
from 2008 onwards, your lordship.
But
Yes.
the maximum, if Lordship goes through this payment, the maximum was during this period, Lordship.
Okay.
And period of commission of crime is between 18 to 22. And this property was bought during this period only, 2019. And Lordship, regarding the reasons of belief, that was really even Lordship will find in the provisional.
Well, no, we are not on that.
It's also there,
Basically, right now we want to know, okay, she has given 2 judgments. I think Kerala High Court and Andhra Pradesh.
2 High Court judgments.
Yes, one is Kerala High Court
And Andhra Pradesh.
and Andhra Pradesh High Court. Have you got any judgments?
Lordship, no, please, today, but
We are on the law.
yes,
Basically, the tribunal, when it rejected their petition, was it, you see, this attachment has been done on the basis of what? The second limb or the third limb of 21U?
second lien, Lordship.
Second limb.
Second lien. If
How-
Lordship goes to the
From
final.
where do you say that?
Lordship, the findings of the tribunal, if we go through Lordship, that is clearly decided. Lordship, findings is at from 301. So where all these judgments has been discussed, including the Kerala judgment also.
301.
301 Lordship, findings of the tribunal.
No.
And Lordship,
Tell us the.
para 14 Lordship, if I read from para 14
Yes.
onwards Lordship.
14 onwards, not 14. Madam, tell us where the tribunal has
Yes.
clearly stated that this attachment has been done in terms of the second limb of 2IU, 2-1U.
Your Lordship, may I just show one particular thing? Your Lordship, may kindly come to page 200, Your Lordship. 206.
200.
206, my.
Yes.
Your Lordship, these are the payment receipts. Started in 2008, Your Lordship, then 2009. This was 6 years. Page 207 is 2009. In 208, it is 2010. 209.
We are not on that.
Just reverting back, Your Lordship, just one more page, if I may just show. I would be happy to
not
answer
submitted
as many questions as required. In 212, Your Lordship, and 213, these are payments made from the salary account of the appellant, Your Lordship. It's from SBI receipts very clearly. So payments were complete by 2001. Just wanted to clarify.
Payments are complete.
2011.
Yes, madam.
Lordship, today I don't have any judgments, but I'll satisfy on the next
Okay.
Lordship.
Interesting. All right. Miss, what is your name?
Miss A. Bhuya, Your Lordship.
Hey, Bhuya.
Your Lordship, just a request, actually, my name and my senior counsel is Dr. P. Agarwal. It's not being recorded in the calls list. If it can be just, the registry may be directed to do so.
Miss A. Bhuya, learned counsel for the petition, for the
Appellant.
huh?
Appellant.
appellant. Praise for setting aside the final order dated 13/8/2025, passed by the appellate tribunal under SAFEMA, SAFEMA, huh? New Delhi. In, what is the case number? MP PMLA 1708.
So that is, Your Lordship, that is the, there are two applications. If Your Lordship may come to page 296, the cause title will refer to
296.
296. Your Lordship. So there were two applications we had filed. One was a stay application, one was an additional document application. The appeal number is 1341.
Okay. In FPA dash PMLA dash 1341 slash GWH slash 2024. Comma, by which the appellant's challenge to the order dated 27/5/2024 passed by the adjudicating authority, confirming the provisional attachment order dated 20/12/2023 pertaining to the residential house of the petition appellant
Appellant.
has been put to challenge. Next part. The appellant's case is that the enforcement directorate could not have attached the residential the residence of the appellant in as much as the same had been purchased by the appellant on 2011,
From 2008 onwards.
between 2008 and 2011, wherein receipts of payment for the same are annexed to the appeal. He submits that the said property was, however, registered in the name of the appellant on 25/6/2009.
Yes.
Though the stand of the respondent is that the commission of the crime from which the appellant received 40 crores out of rupees
40
six,
lakhs.
approximately 40 lakhs,
40 lakhs.
from the approximate crime proceeds of rupees 6 crores,
53 lakhs,
Huh?
74,400.
6,13,74,440. Correct?
Lordship, 6,53,
53.
53.
53. No, 13, I think. Six, 13, 74, 440.
Sorry, Lordship.
Whatever I said, I had lost my paper. For the crime that took place between 11/4/18 to 19/9/23, the appellants have, the respondents have attached the property of the, have illegally attached the property of the appellant, which was brought prior to 11/4/18. The next para, the learned counsel for the appellant, that the same is not permissible in terms of section 2(1) bracket U, 2(1) bracket U. Read with the read with Where is that proceeds of crime?
Proceeds of
There's
crime.
U, and then there's another one that V was there. V is that. And 2 bracket 1 bracket V.
These property.
And-
Yes.
He also submits that the judgment of the Supreme Court in the case of Pavana Dibur versus Directorate of Enforcement 2013 15 SEC 91
2023.
2023 15 SEC 91 has clearly held that
Para 19.
properties which were bought prior to the crime are not covered by the definition and the clause 2 bracket 1 bracket U of the PMLA Act 2002. Listen. Inasmuch as they do not have, they cannot be said to have any connection with the proceeds of crime. As the scheduled offense took place after the purchase of the property. Para 13 of the said judgment states as follows. Next para. Section 21U of the PMLA Act 2012 states as follows. Take it. Next para. The learned counsel for the appellant submits that the learned tribunal had upheld the attachment order on the third limb, on the basis of the third limb of section 2 bracket 1 bracket U. Even though there was nothing to show that the said that the property had been taken or held outside India, which allowed for an equivalent value of the property to be held within India. Equivalent value of some other property to be held within India, to be attached within India. Next paragraph. In this regard, no, so she accordingly submits that unless there is a finding that the proceeds of crime / property are taken or held outside India, a property equivalent in value cannot be attached in India. Next part. In this regard, she has relied upon the decision of the division bench of the Kerala High Court in the case of so and so reported in 2024 SEC Online KER 7343 and the division bench and the decision of the these are not division bench of the Kerala High Court, not division bench, Kerala High Court, and the decision of the Andhra Pradesh High Court in the case of Pensu, reported in 2021 SCC Online AP 983. Next. Miss
L. Devi.
L. Devi appears on behalf of
No, Lordship, as standing counsel in enforcement.
the Standing Council Enforcement Directive, pays for some time to obtain instruction. List the matter on when do you want?
Lordship, after vacation.
Okay, give a date. Vacation. First week, huh? Ninth? No, not ninth. No, earlier to that. Seventh, okay, seventh. First up. The learned counsels for the parties shall, first up, next up. On considering the stand taken by the appellant's counsel, we find that the learned tribunal had dismissed the appeal by holding that even if the proceeds of crime had vanished and was not available with the person accused, properties of equivalent value cannot be attacked. Full stop. Next one. On a perusal of the reason given by the learned tribunal for rejecting the appeal, we are of the view that the issue needs clarification in as much as in as much as the question whether the attachment order had been made on the basis of the second or third limb of section 2 bracket 1 bracket U of the PMLA Act had been applied would have to be clarified. Para 14. Para 14 of the impugned judgment indicates that the second limb of appears to indicate that the second limb of section 2 bracket 1 bracket U of the PMLA Act had been applied for attaching the property of the appellant. Oh. Further, para 15 of the impugned judgment states as follows. Yes, madam. It appears that the second limb has been used.
Your Lordship, it might be the case that they've discussed, but the observation finally is with regards
So we
to
put that, huh? On the next date. Where is that attachment order? Just let us see the attachment.
attachment, your Lord, order, your Lordship is in.
Para 15 of the judgment is there.
So page one,
Huh? Page
I'll
page
take
101, Lordship.
101.
Attachment. 101 onwards.
Effective
101.
portion, your Lordship, is in page 10137 and 138, where again they've referred to the third limb, your Lordship.
107, 108.
137 and 138 is the
One-
effective
one-
observations of the attachment.
137 is the reasons after finding. Reasons to believe.
In para 10, your Lordship, they're relying on the third limb, and para 9.3 as well.
When you say that they rely on the third limb, where is that?
Para 10, your Lordship. Now, therefore, for the reasons, page 138, in exercise of powers conferred upon me under subsection 1 of section 5 of Prevention of Money Laundering Act, I hereby order provisional attachment of the said immovable property. The details, the present,
But where does it show that they have used the word that it has been taken out of India or it is somewhere abroad? Where is that?
it does not, your
It is not.
Lordship. That is what we're saying, that
Next. Mustafa, next up. A perusal of the impugned provisional attachment order dated 20/12/23,
20.
bracket page 101. Does not give any indication that, does not give any indication with certainty that the third limb of section 2 bracket 1 bracket U of the PMLA Act had been the basis for issuing the said order. Does not show.
It does not, sir, your Lordship, it does not mention about the second limb, neither does it mention about the third limb. So it's clearly just a reiteration of what the FIR has. There is no observations. Your Lordship, para 14 and 15, right, your Lordship, these are. I'll just take it. This. Your Lordship has rightly pointed that in para 14 they have mentioned it. Again, towards the end, in page 306, they've also stated when does it go on to equivalent in value. And finally, the observation is relying upon equivalent.
You cannot base your entire case on the word equivalent. Just because they use the word equivalent in the third limb in terms of the in terms of 2(1)U does not mean that that word equivalent cannot be used in the second limb also.
Your Lordship will satisfy this court, clarify on the next date as fixed.
Next, this court this court is also of the tentative view that the use of the word equivalent in the third limb of section 2 bracket 1 bracket U does not mean that the said word equivalent cannot be used in connection with the second limb of section 2 bracket 1 bracket U. Ms. Nektara, Ms. L. Devi shall also produce the records on the basis of which the impugned provisional attachment order has been issued to see as to whether to find out the basis on which the said order has been issued. Full stop. Whether it had been issued on the basis of the second limb or third limb of section 2(1)(u). Okay.
Copy may be provided because this is
Copy of
the
what?
issue.
Your Lordship,
Copy
actually,
of
the
the-
terminology initially we filed it under MAS. Thereby, there was a notification subsequent which directed us to file it under criminal PMLA. So we'll just provide another copy in that case.
This is a matter of this.
So,
So
Most of them.
basically, I don't know whether you've got a good case.
I'll attempt, Your Lordship.
Yes,
to
yes.
satisfy.
Please enlighten us.
Your Lordship may kindly direct our names to be recorded in the cause list.
Registry to reflect the name of
Dr. P. Agarwal and Ms. A. Bhuiyan.
Dr. P. Agarwal and Ms. A. Bhuiyan in the cause book.
Very good lordships. My lord, I pray for some time for filing my written objection.
Huh?
I pray for some time for filing my written objection.
No, what is this? Just explain to me this. Just explain to us this. We want to learn.
My lord.
So what is this? This service tax?
Yeah.
Yeah, has been charged by the assisting officer, correct?
Not so.
On what basis?
On the basis of the Form 26 AS lordship.
Form 26.
AS lordship.
So can service tax is charged for what purpose?
For the purpose of the service rendered to the parties lordship. Here in this case lordship, he has filed nil returns for 3 years, 2014-15
No.
to 2017-18 lordship. But in the ST3 return, he filed nil returns. And on the basis of the date,
In what returns?
nil returns, zero.
In what? In what?
ST3 returns, service tax 3 returns
Service
lordship.
tax, okay, nil return.
Haan,
So
and
so that implies what? That he did not do any work.
they
No, my
don't
lord.
do any work.
So my lord, what is happening is we did work, but the work we did, we exempted. There was a mega notification, mega exemption policy, which was floated by the government of India. Under that and under entry.
So you did work,
Well,
but
yes.
you were exempted.
Yes, my lord.
By some
By a
notification
notification, my lord.
from paying service tax.
My lord. From paying
And
service tax.
only when you gave your return,
My lord.
you
Filed a nil return. Yes, my lord.
saying that you did not do any work.
Yes, my lord.
All
We
you
were
did-
exempted. The work we did, we exempted, my lord.
Then
Then, my lord, they issued us a show cause notice
saying
that on the basis of 26 AS statements collected from third-party data, including income tax authorities, they came to the conclusion that we had rendered certain activities which were payable under service tax, but we did not pay any tax. But the basis,
did they mention about that exemption?
no, my lord, no. They only did a hovering inquiry on the basis of 26 AS statements, and they asked us to produce certain. They issued a show cause come demand notice, and they asked us to submit certain documents. We submitted all the documents as they asked for. However, without perusing the documents or discussing anything about the notification so mentioned or perusing what kind of work we did, they came to the conclusion that we are liable to pay service tax merely on the basis of those 26 AS statements. We appealed the judgment before the learned CSTAT. In the CSTAT also, my lords, we filed all the documents, including the invoices, the purchase bills, everything. The Honorable CSTAT came to the conclusion 2 grounds. They dismissed the appeal on 2 grounds. The first ground is that, my lords, that when the department is assessing service tax, it is their responsibility. They cannot merely rely on 26 AS statements. They have to conduct an investigation. Because the work that is exempted under service tax may not be exempted under income tax. So merely the reason I'm paying income tax will not mean that I will also have to pay service tax. So that is a settled position of law which has been followed by a number of tribunals, including various high courts. So the Honorable CSTAT dismissed their appeal on this is the first ground. The second round, the CSTAT
Dismiss their appeal.
Yes, my lord. I mean, sorry.
Allowed their appeal.
Allowed their appeal. The second round, my lords, they allowed their appeal was the non-issuance of pre-show cause notice consultation, which is mandatory thing. So they did not issue any pre-cause show cause notice consultation in terms of a circular.
What did it say about the exemption granted to you by the notification?
So, my lord, they have to first of all prove with credible evidence. 26A statements cannot be the basis for presumption of that we did some tax.
So what is 26A statement?
26A statements, my lord, basically is the total is a statement which is filed before the income tax authorities stating our gross turnover based on which we pay our income tax. So, my lord, not only sees that.
So this matter, the end of, so basically, so so their entire case rests on the 26A.
Yes, my lord. Yes.
But without going into the issue whether those particular notice
Exempted or not.
exempted certain works that you
Yes.
had done.
Yes.
So that has not been done.
That has not been done.
So what do you have to say?
Lordship, let them file their objection will satisfy your lordship. Because
You show us,
My lord.
26A's notification,
My lord.
which works were exempt
My lord.
and the
My lord,
notification
today,
exempt the notification.
my lord, unfortunately, I do not have copies of all the copies of the exemptions, but my lord, I have the
No, then you give us together. No
My lord.
doing things in
my lord.
half measure. Correct. So otherwise,
lordship.
if we find his case to be true, and that you have not done the work required of you as per the exemptions to be given in terms of the notification, we can send you back to the stage where it should start off afresh.
No, my lord, if I may take your lordship through the judgment of the CSTAT.
Well, yes,
Just 1 minute, my lord. My lord, at page 61.
Yes.
Paragraph 3.
yes.
Shri MP Bagadia, learned chartered accountant, appearing on behalf of the appellant and submits that wide written submission dated 23/12/2019 before the commissioner and during the personal hearing on 5/10/21, the appellant explained that all the works were executed for government departments and are in progress. All the works is exempted. My lord, this part is important. Related documents have already been submitted to the department. He submits that as can be seen from the works, contracts and invoices, the appellant provided the services to PWD authorities, Airport Authority of India, Indian Railways and Oil India Limited in construction, erection, commission, installation, completion, fitting out, repairs, maintenance, renovation or alteration of a road, bridge, tunnel or terminal for road transportation for use by general public. These works are exempt under entry number 13A, 12, 12A, 14 of exemption notification number so and so dated 28/6/2012. So, my lord, all these documents, we not only produce before all our invoices, because, my lord, those are voluminous invoices. We not only produce before the adjudicating officer, but also before the learned CSTAT.
Now we cannot go through those voluminous.
My lord, that's the reason, my lord.
Who will do that? So what is the stand taken by the PWD authorities, the airport authorities?
My lord, that's what they ought to have conducted investigation to find out from those authorities as to whether what kind of services did we render and whether those are.
It is covered by this notification
Yes,
of
my lord.
2000.
My lord, what the CSTAT has come to a conclusion is that they cannot merely come on the basis of 26A statements. The burden of proof, even, my lord, under section 101 of Evidence Act, the burden of proof is on them to discharge. It cannot be on mere presumptions. My lord, may kindly have
So-
para 7.
Para 7.
Yes, my lord. This is the first finding of the tribunal. The appellants submit that they have undertaken various works as per the work orders given by PWD authorities, Airport Authority of India, Indian Railways and Oil India Limited in construction, erection, commissioning, installation, completion, fitting out, repairs, maintenance, renovation or alteration of a road, bridge, tunnel or terminal for road transportation for use by general public. These works are exempt under entry so and so, exempt notification number so and so dated so and so. On going through the order in original, we find that the learned commissioner has confirmed the demand as per the receipts by the appellants as indicated in 26A statements, copies of work orders, wherever submitted by the appellant. Learned commissioner's findings on each of the headings of the work during the various financial years are, however, the noticee failed to submit copies of invoice, bill payment voucher for correlating the payments so received by him, and the nature of work executed. Therefore, the benefit of exemption under so-and-so notification cannot be extended as claimed by the notice, and that therefore I have no other option but to maintain the allegation made in the show cause notice. We find that the manner in which allegations were raised in the show cause notice and confirmed by the impugned order is not legally correct. My lord, this part is important. We find that as the department is alleging that the appellants have evaded payment of service tax, it is incumbent upon the department to prove the same with reliable evidence. We find from the impugned proceeding that the details of payment received by the appellants were gleaned from 26A statements and other documents like ledger, profit and loss, balance sheet, etc. Thereafter, the appellant was asked to submit the necessary details like work orders, invoices, etc. No other investigations to prove the appellants have rendered taxable service and received remuneration for the same were conducted. The department has not even bothered to collect, my lord, this answers my lord's queries. The department has not even bothered to collect necessary documents from the respective government authorities at whose behest the appellant is alleged to have undertaken the work orders. The nature of such works alleged to have been undertaken by the appellants, the taxability thereof under Finance Act 1994, and the exemption, if any available, was not discussed at all in the impugned order. The appellants' contentions that the work undertaken by them were on behalf of the government department and for the use of general public, and that the same are exempt, wide exemption notification number so and so were not at all considered and discussed. Under the circumstance, we hold that the department has not discharged its onus to prove that the appellant is liable to pay service tax. My lord, this part is important. It is a settled principle of law that unless and until the clear analysis of the activity done by the SEC is carried out, demand of service tax cannot be confirmed. Now, my lord, this settled principle of law that before asserting service tax, they have to make a clear-cut analysis of the activity that we are doing, and they cannot merely glean from 26A statements. This has been going on, my lord, since 2007, which has been upheld by various tribunals, CSTAT tribunals, as well as various high courts. So, my lord, the onus is of them to prove that we are doing certain kind of activities from which we are evading service tax.
So this
Without going into that,
service tax is claimed under what provision?
my lord, under Finance Act.
Which provision?
'68, my lords, of the Finance Act.
68.
Yes, my lord.
Finance Act of
1994, Lordship.
1992.
94.
1994. Okay, then this 26AS, this is a form given out under which section or rule or what?
This is by the income tax
Income tax
authorities.
Under what provision? 26AS.
That, my lords, will have to look into it once. But that is basically a gross receipt of the turnover. I mean, the
Maybe, but then
we have found.
it has to have a basis.
My lord. My lord,
26 says now, you said that 26 says is basically a gross turnover.
yes, my lord.
Now, from where do we get that?
My lord, we'll have to come to the Income Tax Act. My lord, I'm not having the Income Tax Act right now, but
We have got the thick one. Decide.
my lord, but one thing is that Income Tax Act and Service Tax, both are independent and different central acts operating in their different domains.
Correct?
So, my lord, just the mere possibility that we are assessable under income tax does not mean, my lord, that we are also
That is why this 26 AS is given under which act?
income tax act, my lord.
Income Tax Act. Let us see. One provision. Just give it to them. I'll give them this.
What's the provision? Rules, my.
Okay, what we'll do is we'll fix the date.
Yes, my lord.
You please read and help us to understand your case, because as what he has said, it seems that you all have not made any inquiry or finding as to how and why he should be why he should pay service tax. Now you'll have to correlate his work with the exemption, saying that this work that he has done is not included in this notification. Exemption. So that is the thing. It's a question of fact.
My lord, I think at this stage it's more of a question of law as to whether the burden of proof is on them to discharge, because the law
No, the question of fact because you are saying that it comes under the notification.
Yes, ma'am.
Exemption.
yes.
Now, they'll have to show that AS26, you have given a list of works that you have done.
Yes, ma'am.
But the list of works that you have done does not find is in the exemption notification. So that's a question of fact.
So, my lord, that has already been decided by the CSTAT, which is the highest fact finding body. And then they came to the conclusion that there is no service tax payable.
Anyway, now the aspect that we are wanting to inform
My lord,
is with regard to
income tax.
So, as he has said, now if the CSTAT has taken a decision to the effect that you have not conducted any inquiry and nothing to show that his work is covered or not covered by the exemption notification. If his submission is admitted by you, then there's nothing to decide here. What?
Then we'll satisfy Lordship in the next date.
Who will
Because
satisfy?
everything
You
is-
are- You're going to satisfy or you're going to ask someone else to appear?
Mr. Cal will be there. Lordship.
I knew. Mr. Cal is always not there. He's always, all his 26 AS matters,
Lordship.
he doesn't come. Why?
See, today he's out of station, Lordship.
Okay. You see, because we have got to understand the issue, and we have got to learn, we want to learn.
My lord, on the next date, I'll produce the number of judgments
Yes.
passed by the learned CSTAT as well as High
The
Court.
only thing is that we have to show us 26 AS is issued for what purpose?
My lord.
And is submitted for what purpose?
Right.
What can be gleaned from 26 AS? Now, from 26 AS, okay, they will find out as to what work you have done, whether service tax is payable or not. So you'll have to show us, as per the Service Tax Act, what services are taxable
Taxable.
and whether the work he has done is taxable and whether the notification under which he claims exemption really covers the work he has done. You've got to show us that.
Lordship.
Otherwise, what is the point of filing this appeal? I don't know. Right. Heard, Mr.
K. Jain.
K. Jain appearing for Mr. S.C. Learned office for the appellant. Who submits that the impugned final order number 75470 /2022 dated 11/8/2022 passed in service tax appeal number 75969 of 2021 by the appellate tribunal Calcutta by CSTAT Calcutta.
State Lordship.
CSTAT Calcutta
Kolkata.
should be set aside. On what ground? Should be set aside on what ground? You don't know the ground.
We have the ground.
Huh?
My lord, they are challenging basically the question of law that the Honorable CSTAT has come to, relying on the various judgments, including Lord Krishna. They are challenging whether as to the Honorable CSTAT has correctly relied on those case laws or not.
Just put them aside. Full stop. The issue pertains to the appellant having where is that, where is the impugned, document, any impugned document?
No, my lord.
Decision? What have I said? Appellant's decision to charge service tax on the works done by the respondent for various government authorities such as PWD,
Airport Authority of India,
Airport Authority. of
Indian
India,
Railways,
And Indian Railways, etc. For the period from
2014 to 2018.
2014 to 28. The next para, the case of the respondent track SSC, on the other hand, is that the works done by the respondent was exempt from service tax in terms of the notification dated
28 June 2012.
28/6/2000. However, the respondent, however, the appellant had taken a decision to charge service tax on the respondent only on the basis of Form 26 AS submitted by the respondent.
No, my lord, we did not submit.
That we
They took
sought
it from
the
third-party
income tax
data.
department.
Huh?
They took it from third-party data.
26 AS from third party
Yes,
data.
my lord.
That is from the income tax department.
Okay, what have I said? No, not submitted by. Form 26 AS received from third parties, taken from third party. Pertaining to the work done by the respondent for the said people. The no pre-notice,
Pre-show cause notice.
no
consultation.
pre-show notice was served upon the respondent by the appellant prior to taking a decision for charging service. And no exercise seems to have been conducted by the appellant to find out whether the various work done by the respondent were exempt from service tax for the said period in terms of the notification dated
28/6/2012.
28/6/2000. Next para. This is the matter when next.
My lord may give me 3 weeks to file my written objection or 2 weeks.
Okay, list the matter of the 3 weeks. In the meantime, the respondent shall file. States Mitra appearing for the respondent shall file affidavit. Clarified. No, stop. The party shall clarify the provision under which Form 26 AS is submitted. And the purpose for which Form 26 AS is submitted to the income tax authority. This is a matter of dividend.
Obliged, my lord.
Before that, you do. Before we do. Not, 8, okay. 8.
I have my wedding during that period.
Oh, the wedding. You come. Quick. Yeah. Okay, after that. Huh?
Much of obliged.
So, yeah, where? Here in Guwahati?
My lord, Tura.
Huh?
Guwahati as well as in Tura.
Tura, okay. Interstate marriage.
Yes, my lord.
Okay. Good.
Obliged, my lords.
Jail appeal lordship.
This is a jail appeal against the impugned judgment dated 29/1/24 passed by the Court of the Additional Sessions Judge cum Special Judge bracket POCSO at Barpita. In Special POCSO case number 53 of 2020, arising out of Sarthe Bari PS case number 200/2020, by which the appellant has been convicted under section 363 IPC slash 4/2 of the POCSO Act. Admit the appeal, call for the TCR, issue notice to the respondents, returnable in 4 weeks. Ms. A. Begum, additional PP appears for the state. Registry to furnish a soft copy of the appeal petition to the office of the PP,
Lordship.
who shall thereafter furnish the same to the concerned OC for service of notice to the to whom? To-
Respondent number,
No, there's no respondent here. To There's no PW2. To the, wait, where is it written? Parcel, where is the address? Not here. To the informant father. We don't know who it is.
we don't have the copy, Lordship.
Huh?
We don't have the copy as it is jail appeal, Lordship.
Uh-huh.
So,
We'll listen after. This is a matter.
And amicus may be appointed, Lordship.
My case, who do we appoint? Who do you want? Huh? Shri? Shri Mrinmoy Khatane is appointed the amicus curiae.
It's also jail appeal, Lordship.
Right. This is a jail appeal against the impugned judgment dated 18/8/25 passed by the second judge Biswanath, Biswanath Karyali in sections case number 107 of 2018, by which the appellant has been convicted under section 302 IPC. Admit the appeal. Call for the TCR. Ms. R.D. Majumdar is appointed the amicus. This is the matter after 4 weeks.
May I please, Your Lordship?
Ms. L. Devi, Lieutenant Counsel for the appellant. Submits that the impugned judgment dated 27/8/24 passed by the additional sessions judge cum special judge bracket POCSO, Morigaon. In POCSO case number 167 of 2022, arising out of Jaggi Road PS case number 273/2022, by which the appellant has been convicted under section 6 of the POCSO Act. Should be satisfied. Admit the appeal, call for the TCR, Ms. Abigam, APP appears for the state. The appellant shall take shall serve a.
Lordship, notice is issued, Lordship, and it is received.
Notice already issued, where? Oh, no.
Hey, I mean, you know,
For the first time.
This is for the IA.
It's not
Why?
first time, madam.
This is for the IA, Lordship. The IA is 15 Lordship.
He was there.
It was Lordship
Okay,
received
right.
by the respondent number.
Right,
IA receipt.
no, don't say issue notice, huh? Don't say.
And objection.
Which A become additional 50 appears for the state. No one appears for the respondent number 2, even though notice has been served upon the respondent number 2 in at the time of disposal of the IA for condoning the delay in filing them. List the matter of full.
Yeah.
How can it be called for? But TCR, call for TCR.
May I please, my lord, it is a criminal appeal filed against the order dated 04/07/25. Thereby rejecting the bail application of the appellant by this.
Why should it be allowed?
It is allowed already, my lord. The IA has been already
There has been an
disposed.
IA of condoning 42 days of delay in filing. That IA has been allowed.
Allowed already, my lord.
No, that is all right. Why
This
should
appeal has been listed for the first time.
Okay, so we have to issue notice.
Yes, my lord.
Okay, heard Mr.
A was submitted, my lord.
A. Baskumatari, learned counsel for the appellant, who submits that the order dated 4/7/25
In
passed by the special NIA, passed by the NIA court in special NIA case number 5/2024 bracket new,
yes, my lord.
rejecting the bail application of the petitioner of the appellant should be set aside. Issue notice returnable in 4 weeks, Mr.
D. Bharadwaj.
D. Bhardwaj appears for the NIA. This is the matter after 4 weeks to enable the respondents to file affidavit. Am I finished?
Congratulations.
To file the written objection. It is.
Yes, sir.
Have you been given a copy of the
This,
peace book?
no, my lord.
Huh?
This, in this appeal, my lord, notice may be issued to the respondent number 2.
No need. 302.
IA for bail may be had after 4 weeks, my lord.
If you want, we can hear it now also.
Today I am,
Not prepared.
difficulties is going on. Some difficulties is going on. After 4 weeks, maybe had I.
Why? We will hear your entire appeal.
Yes, ma'am.
Why I only?
IA for bail.
You're not prepared.
No, I am not preparing today.
You're not prepared today.
No, ma'am. After 4 weeks, IA and appeal
No,
may be had.
after 4 weeks we'll hear everything.
Yes.
No.
After 4 weeks, it may be hard, my lord.
Paper book is ready then after 4 weeks.
Have you
final
been,
hearing.
I think you've been given a.
Receive the paper book.
Yes. You have also been given paper book.
Yes, ma'am.
Right. Mr.
As thus.
S. Das, learned counsel for the appellant, submits that he has been given a copy of the paper book and submits that the entire matter can be heard
Yeah.
after 4 weeks. Ms. A. Begum and APP also submit that she has received a copy of the paper book. On the prayer of the appellant's counsel, list the matter on, give a date. For hearing. No, give it before 3rd February. Give it a short date. Yeah, give it in January between that first week or 2 weeks. Not 8, 7th. Yeah.
May I please, your lordship. Lordship, that appellant was convicted under section 6 of POCSO Act, my lord, for 20 years, my lord.
Legal aid counsel for the appellant and Ms. B. Boyan. Learned counsel, learned APP submit that the book has been furnished. to them. List the matter for hearing on. After.
Usual course,
Ah, okay, usual.
2024 matter.
Usual. Yes, madam, respondent number 2. Okay, copy was served and the wife. The copy was served and the wife. The number also has been served. Okay, right. Which for the right, no one appears for the appellant. Miss B. Buyan, APP appears for the state. The inspector of, the officer in charge of the Bogaigaon Police Station has submitted a letter dated 1/8/2025 to the effect that the copy of the notice was served upon the wife of, that is point number 2. Further, a copy of the notice was also sent to the respondent number 2 in his WhatsApp number 863-834-7520. Accordingly, notice is deemed to be served upon the respondent number 2. As paper book has arrived,
Lordship, I have not received.
registry to make the paper book.
But TCR has arrived.
As PCR has arrived, registry to prepare the paper book. This is the matter of proposal.
May I please your lordship, my lord? My lord, second, I am my lord for confirmation of delay. And my lord, on the last occasion, my lord, 1/9/25, notice was issued, but my lord, due to some, my lord, some miscommunication, my lord, the order has been reflected, my lord, second page, order dated 1/9/25, my lord.
Yes,
It was, I'm reading, my lord, in the next page. He further submits that, this is my lord petitioner myself, the area maintenance amount has been deposited, my lord. My lord, this is my lord, some misconception, my lord, on this part, my lord, and honestly, my lord, petitioner, my lord, in this case,
That entire matter may be hard mine. January, they were in matter, January, my.
so you see one thing, the paper book has been made in
But
one.
it is not made available to me.
So we will, because the paper book has been made,
Definitely one photocopy of the that will be served on
Person
me.
is called-
Maybe.
The cost is called, right? Good night.
In my case, my lord, it is not served on me.
no, should be that, should be that. No, so you see, it comes out from the same judgment.
Same judgment, two accused, there are two repeat.
The paper book has been made in 104.
Yes.
104, we have received.
Is another co-accused, another co-convict.
He's appearing for him.
So in 4, so this 104 can be used for
Yes,
both.
ma'am. So that,
So we'll direct that the registry should furnish copies of the paper book in 104/2024 to
my
Mr.
junior is that
T Gogoi.
Huh?
T Gogoi,
T. Gogoi. You're in which case? You're in the
17 your lordship.
145.
145, yes.
And who else? Mr. Thaiki also, you're not been given.
No,
You
I
have been
think
given, I think. You have got, no, there's no need. Then you also have got only for you, I think. No one else is required. No?
my lord.
Okay, right. Right. Mr. T.J. Mahanta appears along with Mr. Tigo for the appellant in 145 criminal appeal 145/2020. Mr. I.H. Shaikia appears for the appellant in Criminal Appeal 104 of 2024. Ms. B. Boyan, APP, appears for the state. The paper book that has been prepared in Criminal Appeal number 104/2024 can also be used in Criminal Appeal 145/2024. As both the appeals arise out of the same impugned judgment. Accordingly, will you take a photocopy or you take a photocopy from, make a photocopy, better, or you don't have?
It doesn't get misplaced again. Our office, luckily today, they have provided us with a copy.
Definitely. Definitely, I'll make that.
You make photocopy, best, or do we direct the registry again?
Registry may be directed.
Hey, let them pay, yeah.
Just make a photocopy. Yes.
The TJ Mahanta submit
Yeah,
that
yeah.
he will make a photocopy of the paper book, of the paper book from
No,
the AP's copy.
Yeah, but-
Oh, yeah.
Made a photocopy of the paper book. Accordingly, leave this matter for hearing.
Yes, that is only mine. That ঠিক আছে, I'll give, yeah, don't worry. In February.
Excuse me.
We've got a lot of matters.
And in the month of January, only 13 days are working days.
We've got a lot of matters.
I've seen my love, and January very less working days.
Yes. All. In fact, while you are enjoying your Bihu Pujas, I'll be busy. Because we're going to have some function, no, during the holidays.
Time being item 9.
Ah.
Lordship,
Madam, item
Lordship, item 9, Lordship.
9,
PW2, Lordship.
yes, page 11. Yes,
But I find also that, should I read, Lordship?
yes.
I know the informant Sri Kolom Singh Terong. I also know the accused Sri Mohan Terong, who is my father. I also know that this is Noli Terong P, who was my mother. The occurrence took place on 17/7/2019. On the day of occurrence, I, along with my husband Sri Jersong Ronghang, my deceased mother Noli Terong, my accused father Sri Mohan Terong, and one of my elder brothers Sri Sonu Terong, were staying together at our house. On that day, at about 4 a.m., on hearing a scream, I went out and saw my father had assaulted my deceased mother on head with a wooden log many times. So that many times, what, Lordship, I do not find support from medical evidence, Lordship. No? Blood came out from the injury. The witnessing that I made hue and cry, and hearing my cry, my grandfather Sri Kolom Singh Terong, grandmother Sri Kachi Baipi, and people from the neighbors came there. Thereafter, I, along with my husband, took my mother to hospital situated at Dhilai. Doctor examined her and declared her dead. After that, my mother was brought to our house, and my grandfather Sri Kolom Singh Terong had informed the matter to the police. Later on, dead body of my mother was brought to civil hospital, Difu, for postmortem. And the magistrate inquest the dead body. On inquest report, I put my signature as a witness. Exhibit 4 is the inquest report. Exhibit 4.1 is my signature. The relationship between my mother and father was good. There was no fight between them. On the day of occurrence, there was no quarrel between my father and the deceased mother. It is not a fact that I did not see the beating of my mother by my father. It is not a fact that the door was tied with chain, so I did not see what had happened inside the room. After the incident, Sri John Terang, Malati Terang P, and Mohima Terang P reached our home. So this is her statement. And here in this case, Lordship, the informant is a police official, Lordship, retired police official. and the present FIR was lodged, Lordship, at about 4:30 PM, Lordship. And prior to that, on the basis of GD entry, inquest was done, seizure was made, and Lordship, that GD entry is not exhibited in the present case, Lordship. Although the informant is a police official, he knows that the FIR has to be lodged promptly, Lordship.
Anything else?
And regarding that, Lordship, she says, Lordship, many times, but what I find, Lordship, that one injury and other hematoma. That
A difficult case.
happens, yes. And he was represented by legal counsel, so I am not commenting on that. Some cross-examination could have been clarified that aspect. That.
But then still, it is too clear cut.
But Lordship may consider that aspect, that converting the case, Lordship, because one blow and there was previously there was no quarrel. That part is.
How do we do it? Legally, you tell me how to do it. You are an expert how to do it. It has to come within the exceptions to 300%.
Lordship.
Unless that can be shown, we just cannot convert. No. If you can show me the way to do it legally, it's all right. Otherwise, very difficult for us also.
Lordship. That I understand.
Because no, understandable.
Lordship.
Some case, but we have got to do it in a proper manner.
Lordship.
We cannot do it as we want.
Lordship.
That is the problem.
Lordship.
I know your case is also very difficult. It's very too clear. There's not even a he's 17 at that time, probably.
Lordship.
17, 18, and
18
he's
years.
married.
No.
There's nothing between everything is within the family. Very difficult.
But at the same time, Lordship, may I see that insurance report, Lordship,
Ah,
that
okay.
page 68.
Yes.
Although, Lordship, that itself is not a ground for disbelieving the eyewitness, but Lordship, may kindly see page 71 part, Lordship,
Yes.
that in presence of that officers, Lordship, that opinion of witness and police about the case of dead and weapon or instrument used thereof, if any, hit by a blunt wooden piece. But more information that, Lordship, regarding that father committed, that has not been stated at the initial stage. Therefore, I said, Lordship, that delay was there and the initial GD entry was not exhibited. That and the inquest was done on the basis of, Lordship, that GD entry.
The wood was seized,
Yes.
Yes, that was seen,
Wedding
Lordship.
apparel was seized.
exhibited also.
Exhibited, but fingerprints were not
Wood, what fingerprints will you get? Unless it is polished wood with wax or something, you will not get any fingerprint.
But that observation is not.
You catch hold of a stick, you send it for fingerprint, you will not get anything. No, nothing will be shown. Wood, so there's no question. Unless it is wax.
No. Only on delay part, Lordship may consider that. I am just relying on one.
Delay, what do you mean delay? Like?
Delay of Lordship lodging the Azahar. That judgment which I am relying, there Lordship 12 hours delay was there. And that was even eyewitness was there and the Supreme Court considered that aspect, Lordship. 2003, 13 SCC, Lordship.
2003?
3 SCC.
3 SCC.
3 SCC, 355.
2003, 3 SCC?
355.
355.
Yes, para 12 to 14.
On delay in FIR.
Delay in FIR. 12 hours delay was there in that case, Lordship. In my case also.
It's a 77.
No, before what I am pointing out before, Lordship, is that that inquest was done, seizure was there. So police already arrived there by 12 noon, Lordship. They could have if the witness that PW2 was present there, she could have informed the police that father has committed this offense. So the police will register that FIR. But that was not done. That is what I am trying to place, because the informant is also a police official who subsequently, Lordship, came into
Retired
picture.
police officer.
That he is the retired police officer, Lordship. That page 3, your Lordship will get.
It's done on the same day.
Yes,
The same date, but,
7709.
about Lordship 11 hours.
7719. Same day, my
Delay
lord.
of 11 hours or 12 hours itself will not be fatal. What I am pointing out is that, Lordship, because, Lordship, that police already arrived there. They could have informed the police about the culprit, Lordship, at the initial point of time.
Column
Doesn't difficult, this case. Okay. Very difficult.
Because these are the things which I can at least point out before your lordship.
Correct.
That
So one is delay in FIR,
lordship.
delay in FIR, then number two.
Said that seizure and inquest and postmortem was done in connection with GD entry. That was not
Just
executed.
a minute, Caesar
Seizure, inquest, and postmortem
and postmortem
was done in connection with GD entry number 323.
in connection with GD entry number
323.
323 of 2019.
19.
19.
332. 332.
323.
It is 332. PM page 73. Delay GD entry 332.
Therefore, it is because. Inquest, yes. In inquest, it is written as 332.
So it will be 332.
333.
332. So what is wrong with this?
So that GD entry was not exhibited. That what was the initial information?
And the FIR was exhibited as FIR.
No.
GD entry is different.
Yes, GD entry is different.
What is the FIR GD entry?
323.
Where is typographical error?
323.
3.
No. 323 of 2019.
Lots.
Yes, fine.
This is earlier.
Highly owned.
FIR is earlier than.
Yes,
Can it be? Cannot be.
cannot be, that cannot be lost.
Cannot be. It has to be later.
Later. Page 1 and page 73, Lordship may compare.
Page 1,
Yes,
323.
yes,
FIR.
yes. And inquest report, page 68 is there.
Page 68.
Record to demon.
332.
332. And Lordship, postmortem also that page 73, 332.
332 GD entries.
Page 68 and 71.
73, Lordship. 73. And seizure, Lordship, page 64. That also relates to Lordship, GDNT 332. And time of seizure is
This is Caesar memo.
yes, page 64 is seizure memo in connection with GDNT.
Fifty.
Yes.
I think they mean to say
323 cases.
In Lordship, original it is 323, different GDNT.
what is 323? The GD
GDNT. In the FIR first page, Lordship, that is correct with Lordship original copy. That no typographical error is there.
page.
Yes, page 1,
This page. 323.
323. That is correct.
So must be mistake.
No, sir, no mistake is there. In the original copy also the same thing. No typographical error.
This was registered at what time?
So that is what I am pointing out that GD entries were not exhibited.
No, this is occurrence. This is occurrence.
Yes.
This is when was the FIR registered?
FIR was registered on Lordship 17/7/19.
Correct.
That's it.
4 p.m.
Lordship.
4 p.m.
Oh, no.
And let us see this Caesar memo was done when?
Seizure was done page 64, 12:30 p.m.
PM.
12:30.
4 p.m. 3 p.m.
Yes.
12:30 p.m. 12:30 p.m.
12:30 noon. No,
Is it noon or
Noon.
because 30 p.m.? Huh?
PM,
Those
afternoon.
have been-
It will be
noon,
afternoon.
huh? That means वजन again जाएगा हाँ
Incident occurred in the early morning, 4:30 a.m.
Yeah, about 332.
okay so the information must have come earlier so
So
did
that
it
is why I'm
still it is 332
no
It should be-
332 regarding the
332 is after 2323
332 extract of GD. Dated 17/7.
madam you see
No.
if FIR is filed FIR number is 323
Yes.
but the GD entry on the basis of which inquest everything was done
Done.
was earlier in point of time
Yes.
but that has been given 332
number is
number is
frequent.
You see, it has to be a subsequent number
Yes.
after after 332.
Also,
The FIR should be not 323, it should be after 332.
after 332.
But that number is not there. No, some mistake. Well, anyway, it doesn't change the fact.
That only thing, Lordship, that initial that prosecution case was not disclosed.
And anything else? One?
And Lordship, that regarding injury part, Lordship,
Yeah.
that single blow, no previous quarrel, Lordship. So therefore, my prayer would be to convert that hit of the woman. Lordship.
Lordship, this GD entry was lost on an information given by VDP secretary over phone.
Maybe,
Yes,
madam, one thing is this.
my lord.
Supposing now information comes to us,
Lordship,
we say we give it number 3.
my lord.
Supposing information comes tomorrow, it cannot be 2. It has to be after 3.
My lord.
So that is what we are saying.
Yes, my lord.
You see the inquest and everything, the GD entry is 332.
Yes.
FIR is after the inquest.
Mm.
And after that GD entry of 332.
Yes, my lord.
So the FIR, when you register as GD entry, that will be after 332.
Yes, ma'am.
no? So it was not prior to 332,
Mhm.
323.
Mhm.
Some mistake has occurred.
Mistake.
Is it 2 different police stations?
No, same police station.
Delay.
Or is it that FIR is recorded separately and this information is recorded separately?
No, the GD entry book is same.
GD entry.
GD entry book is same. So once they receive the information, they have to record it.
Okay. Okay, right. Heard Mr. A. Amit, Leonard, Mike is correct. Also heard Ms. B. Buyan, Leonard PPP. Okay, and Ms. K. Pukan, Leonard, Legal Aid Council for that's point number 2. What have you got to say? Huh?
Not bail, the entire. Bail no আছে, hearing was.
They've got no clue of what's going on, madam. Okay, anyway, doesn't matter. After hearing the counsels for at some length, is it? No, okay. Hearing concluded, judgment is that.
Oh, he's in jail.
Okay, I've got to go here. I will be that soon. Please get up.
Also, item number 15 can it be taken up any other day?
Kuntu?
Okay.
There, Lordship, I have recently filed Wakalat and I found that in the
Oh.
FIR, there is some typographical mistakes are there. So I have to check all the,
Ujjwal.
Ujjwal.
Mr. A. Amit, list the matter after
Ujjwal lege.
the vacation.
So the date may be fixed after
Yes,
winter.
February,
January first week.
January to February.
No, because I will, on that day only I will place the
Okay,
corrected copy.
give some date.
Offline.
What about item 16?
16 to Sarvanan lege. Come here.
14 we are ready, Lordship.
14 already, okay, we'll do it.
Yes.
2. Right, the next.
My basic argument will be, Lordship, of section 3G 300 exceptions, Lordship.
Hmm.
On exceptions, I'll be arguing, Lordship, because from the FIR itself, it is here that there was a
He assaulted his mother.
yes, mother
Mother died.
died. And as far as Lordship, eyewitness, what my learned friend is saying about PW2 Lordship, in her cross-examination, which is on page 12 Lordship, or should I read all the witnesses Lordship?
Look, PW1
Yes, he's the Gaumbura.
is the Kambura.
He lost the FIR on being informed by PW2.
So but so PW2 was the wife of the appellant,
Yes, yes,
saying that the appellant had assaulted his mother.
yes. But Lordship, in cross-examination, if we see, the altercation between the accused and the deceased took place in the courtyard of our house. Now, the important part, at the time of altercation with the accused and deceased, I was inside the
Page number
12, Lordship.
12.
12.
That is evidence of PW
2 cross 2.
two. Yes, the author
That
said, yes.
there is no eyewitness to show that I'm showing Lordship this part. After the deceased fell down on the ground, I came out from my room. So Lordship, the actual assault was not seen by her also. After she fell down.
But it was inside the house. There's no one else.
No, I'm not saying, Lordship, that the incident did not happen. I'm just on, Lordship, from 302, it can be converted to 304. I have a judgment.
Because out here, under section 106, the best person to explain would be the appellant. And what did he say?
He, in his 313, he has denied, Lordship.
313 denied.
Yes. He says, at question number 21, he says, do you have anything to say? He said, I am falsely implicated in the case. I did not assault my mother. But 313 itself is not a yes. So I'm not going by that, Lordship. I'm going by the evidence that there was a death. There was a death of a mother. So, Lordship, what I'm saying, what I'm submitting, Lordship, that since they were in the FIR itself, it is mentioned that they had a fight, altercation.
But PW3,
3. Yes, Lordship.
the last line, 14,
Yes.
last sentence. I heard one sound. Page 14, bottom.
Yes. No, Lordship, we have to read. Lordship, before that, I'll read from on the day of occurrence, I went to the house of accused as accused was ill. In ill, it is written.
Mm.
The accused was ill, in fact, Lordship.
Mm.
While I was in the house of the accused, I heard one sound and I saw that the accused had hit his mother with a wooden lathi.
So
Then, Lordship, let's come to cross. I did not see the assault by the accused. So, totally, that is, yeah. Totally demolished the chief, Lordship.
But it is not the fact that the accused did not assault the mother, deceased.
let us see the Assamese thing. Was it in, this is the vernacular evidence.
English.
In vernacular or is it in, it is recorded in English.
It in English, Lordship.
Recorded in English.
Because the signatures are there in the
It-
paper
yes.
given to us. So, Lordship, in fact,
I did.
Doctor is corroborating with the injury letter.
No, he has done it.
He has done it.
Yes.
And it was, the issue was
to
not
one
drink.
judge-
Evidences.
one
He was
judgment,
instructed
Lordship,
not to
one
drink.
judgment
Uh-huh.
where there is a wooden and the injury is on the head. Apex court held that I mean
Lathi.
lathi and
That Lathi judgment, okay.
lathi, many judgments are there, but this judgment supports me, Lordship. Some lathi judgment do not support
Okay. Tara?
Lordship. I'm just opening mine. Relevant para, Lordship. Like you,
Need to.
Huh?
Need to be.
Lordship, my thing is not.
It doesn't come. No net comes here properly, Lordship.
No, that comes here probably.
Jio also, Airtel also, Lordship. So, opening.
নুখুলে নেকি?
কষ্ট হয় শুনবা আপনার কি
But very short judgment, Lordship, that one. And in many paragraphs, the lathi cases are discussed, Lordship. Oh,
Lordship, in 313, there is also one question, Lordship, that is question number 6, Lordship, page number 29. I'm reading the answer. This is not true. In the morning, I had argument with my mother with regard to taking liquor. Then my mother went out to the village and somebody assaulted her and caused injury. He is denying, Lordship, that he have injured, but the fact is that there was a liquor argument was there, Lordship.
Lordship, from paragraph 7, Lordship. I said it. I'll read, Lordship.
Yes.
A lathi is a common item carried by a villager in this country linked to his identity. The fact that it is only capable of being used as a weapon of assault does not make it a weapon of assault simpliciter. In a case like the present, as of an assault on the head with the lathi, it is always question fact in each case whether there was intention to cause death or only knowledge that death was likely to occur. So, Lordship, in our case also, I'm saying there was no intention, Lordship. They had an altercation and he just hit his mother with the. So maybe he had the knowledge that.
It's not every day that someone hits his mother with a lathi.
That's true, Lordship. That is true. So it's a sad fact. But then.
It's a very, very, very rare occasion.
But he was under influence of alcohol and he was sick, Lordship. That the prosecution witnessed him.
No, but then you see,
He was sick. Lordship?
On the spot.
Lordship.
No, she was taken to
Hospital, but,
auto driver was examined. Lordship.
That alcohol cannot be, you cannot.
No, I'm not taking a defense of alcohol, Lordship, because it cannot be. Alcohol defense is that someone must have given poured into him, and then only that defense.
And also without his consent.
Yes, without his consent.
And then the mental health issue, I don't think that is the ground that they have taken.
Auto driver, independent witness.
He's ill means nothing.
No, I'm just saying, Lordship, that whether the mother said something, like some person came and two versions have come on that also, Lordship. One version says that someone came and mother asked that person to sit on his bed. And another version is that mother asked him not to take alcohol and he got angry because of that. So two versions are, that contradiction is there from the prosecution witness itself. Why the incident happened, why he assaulted. So that is, Lordship, PW 1 and 2 are the contradicting people in that regard, Lordship. And moreover, Lordship, some witnesses who were there, the neighbors, Lordship, they were not examined. They were mentioned, Lordship, PW 1 itself mentioned that the father of the accused and they were there, Dosing Ronghang, he was not examined. Then Kawe Timumpi is the mother. The father was not examined, Lordship, who was also present. That will be at page 9, Lordship. And contradiction part, Lordship. Contradiction part for PW 1, Lordship, page 9. He says in cross-examination, Srimati Rima Kropi told me that deceased was assaulted by the accused as while he was sleeping on his bed, one guest came to their home, and then while the mother of the accused took the guest to his bed to be seated, then the accused had assaulted the deceased mother in anger. This is PW 1. Now, Lordship, PW 2 says that at page 11, Lordship, I was at home on the day of occurrence at about 1:30 p.m. The deceased Kawe Timungpi told the accused that as you were suffering from fever, you should not take alcohol. Then the accused got anger and assaulted the deceased with a wooden batam on the head of the accused, and she fell down on the ground. Lordship, now here what as per the PW 1 that they were inside the house. If we believe PW 1, Lordship, they were inside the house and some people came and the mothers had taken the guest to the bed to be seated, Lordship. But in cross-examination, PW 2 says, the wife, Lordship, that the incident had taken place in the courtyard. There are too many contradictions, but instead of going to those, that there was no sudden provocation. That exception, Lordship, 4.
So how do you prove that the exceptions to section 100 are factual?
Lordship, by the evidence of the prosecution witness itself, that they had an altercation. FIR itself mentioned that they had an altercation. Altercation means there will be provocation, Lordship. Had an altercation with his mother, and PW 1 and 2 both mention about altercation.
Sentence to life.
Life. My humble submission, Lordship, it can be converted. This is a fit case to convert, Lordship.
How old is the
Accused. Accused, Lordship. At that time, he was 33 in 22. 25.
36 now?
33. Yes, no, it's very long. 22 plus.
How long has he been in jail?
From the day of his arrest, Lordship. 21 on incident.
Lordship, there may be some discrepancy, Lordship, but the fact remains same. There is an altercation as he was fever and mother have said him not to drink. On that, there is no provocation, only for safety of our own son, Lordship. Then not wooden lathi, Lordship, it's wooden batam, Lordship. It's a batam. Lathi is something else. So, Lordship, though he have no intention, but he knows, Lordship. If he can hit in the body in some other part, then it's something else, Lordship. But he have hit in her head, Lordship. Batam. Batam.
But bottom was not sent for FSL or
It's not
anything.
so
And there was
fatal.
no blood also on the bottom. The IO said that.
And Lordship, own wife, his wife, Lordship. There is no animosity between them. That she will give a wrong information, Lordship. And there are her sister too, Lordship. PW3. And the auto wala PW6, Lordship, who have taken her to the medical, Lordship. First to the pharmacy, then later to the medical, Lordship.
You fled also, you fled away.
Right? Means he had gone to consume again alcohol or something like that. That has come.
So he's
I'm
not that-
submitting
he-
fairly, Lordship, I'm submitting fairly.
No,
But the thing is, Lordship,
just imagine, his mother died. Supposing he did not have a hand in it.
Lordship,
Supposing he did not do it.
Lordship, no, I am not saying he did not. Lordship, when something happens, 4 situations take place. It is either flight, fight, freeze, or face. So 4 situations happen. In any situation, Lordship, we behave in four ways, Lordship. So don't Lordship that he
Yeah, this is the 5th. The answer you have given is the 5th. He has not fled. He's going to go and collect his daily quota or something like that.
fried,
forgot to take his
Lordship.
mother to the
Lordship, no, fried, Lordship. He did the incident.
Where is that he had gone to drink? Because from PW1 it says that he had fled away after the operation.
No, somewhere I found, Lordship, he said that he had gone to, let me check, Lordship, maybe. Lordship, his question 6, Lordship.
In his he did.
Because they got to taking place, remember the event. Oh.
So 10. Question of this. I did not guess because I would take this. Where?
So that's what. There is no fright. There is no
Sympathy or something.
running away.
But Lordship, it is
Don't
fried.
have a drink. As if he's having his morning cup.
No, Lordship, it is fried. It is fried. What he did, he realized the next moment, Lordship, they are not very learned people. They are very common villagers. So it is fried. It is not, he could not face.
Reflexes from his answer.
We cannot be psychologists, no, that he says that he's gone for a drink. Who are you to say that he's scared? There's nothing to show that he's scared.
Lordship, then there is also nothing to show that he did it.
Correct.
no eyewitness, there is nothing.
No, no.
Then I'll go for good.
No, that is the issue. Now, he was seen there after the incident. His mother had fallen down. So a normal person would look after his mother straight away. But he goes for a drink.
Lordship, my understanding is that it falls under the exception because the mother provoked him.
How?
By two versions are given. I do not know how the prosecution has proved that that incident itself, Lordship, when they are giving two versions. And even if we go by both versions, he was ill. Prosecution witnesses says that he was ill, and that is why PW3 came to their house. And Lordship, since he was ill, the mother brings in someone to sit on his bed or whatever they are saying. So he gets irritated by that. Second version is that the mother said you should not take alcohol. So that provocation, Lordship. Altercation,
No, don't take alcohol is a provocation.
Lordship,
PW4 have also said, Lordship, that I did not find the accused as he fled away. So he fled away. PW4, page number 17.
That explanation could be an afterthought. A normal person won't go and have a drink. to
Lordship,
straight over that.
it is impossible, Lordship. A mother will feel that if by mistake also he did something, he will only carry her mother, Lordship. He will not leave her in that condition.
Very badly taken.
And the halla huniye hai ulai.
And they reported that because lawyer gave certificate. Yeah. Getting the evidence, very other separately.
But shall not be silly.
Giving another take. Ask any question number.
There's nothing, in cross also you have got out from PW2, 3. Why should the wife,
Give a false,
the
implicate the accused, Lordship.
accused,
no,
her own husband?
There is
that's
no
why, Lordship, I'm not on the fact that he did not do. I'm not on that. I'm accepting.
You are accepting that.
I'm accepting
Only
that.
thing you are
From
saying
there, I'm saying that
You're
to
saying it
convert.
ought to be converted.
Yes.
Because, but the thing, how do we overlook the head injury to also with a
wooden button.
No, that Batam was not sent for FSL, Lordship.
It is
That,
not-
that,
It's
not
that, if this court is, holding PW2 as a trustworthy witness, 2 and 3, we have said, which is corroborated by PW3.
two, Lordship, that is why, Lordship, the version of 1 and 2 are not matching. They are contradictory.
One unit is the
Gaubura, he is
We are not concerned with that. 2 and 3 are your.
in the house, in the house.
2 and 3 are the private.
No, Lordship, but then, Lordship, if we go by 2 itself, Lordship, in page 11, I was at home. She is saying that he was suffering from fever.
That's all right.
She herself is saying, if in that, if someone is not bodily fit, Lordship, at that time, if someone provokes
What is there to provoke?
Provoking, not then.
Tell, mother is saying, don't take alcohol.
he might be
How can-
taking it as a provocation, Lordship. That's
Huh?
the, yeah. So, he was suffering from fever. And then if some guest comes and they make him sit.
Where are the guests?
No, that is what PW1 has said, Lordship. That is what PW1 has said, that
PW1
he was
that is
sick.
after information. He got the information, then
Sure. Not-
he had the
When he
incident.
had come, the mother had already been taken to the
Hospital. He had from the PW2.
He has not taken a plea of alibi. No.
No.
He has not taken a plea of alibi. So he was there at the time his mother fell down.
Fell down.
Now that is an added
No.
circumstantial evidence against him. Because he'll have to explain as to how his mother fell down and died.
So that's why, Lordship, I am not.
I know. What I'm just trying to say is that
Yes.
first we have got to prove the guilt of that murder has been there.
Huh.
It's
But
only
if-
after that we can go to the next step.
But if we go by PW1 and 2, the contradictions they said about the incident itself, Lordship, that will show that whether a reasonable doubt is, created by that. Whether the incident happened as they are saying, Lordship.
Well, one thing is clear, there was no one else
Uh,
tells them.
uh,
And grave has to be not as per normal person, normal person, how you see it to be, whether it's grave or not. Yes.
Exception 4, Lordship, which reads as culpable homicide is not murder if it is committed without premeditation in a sudden fight in the heat of passion upon a sudden quarrel.
So you see one problem there. 4 requires a provocation, which results in a sudden.
Provocation is in 1, Lordship.
One is there. One
If-
is provocation, but 4 requires the provocation to ultimately lead to a fight.
Committed without premeditation in a sudden fight in the heat of passion upon a sudden quarrel.
Where
And-
is the fight here? There was no quarrel.
Nothing.
She simply
No, quarrel
said-
is there, Lordship. They have said they had quarrel.
She
They,
simply asked us not to drink.
Drink.
no, they had a quarrel, the altercation between the accused and the deceased.
That was the mother.
Altercation, Lordship. And the FIR itself mentions that they had a altercation. That means
Those are the people who heard about it. PW2 is the best person.
yes, she herself is sick. Lordship, she herself will
You
face.
that as you were suffering from fever, you should not take alcohol. Then the accused got anger and assaulted the deceased with a wooden baton on the head of the deceased, and she fell down on the ground.
In cross, she's saying about altercation, Lordship. The altercation, her cross first part. Between the accused and deceased took place in the courtyard of her house. So,
Clarification is she's referring to what she said in chief. Yeah, clarification.
yes, Lordship, if they were inside the house, then why the altercation again? Why in the cross she's saying that the contradiction between her evidence, Lordship. In chief, she's saying something. In cross, something else is coming out.
His answer. Why she heard, she saw you hit, she saw blood oozing out, the heavy hits it. I do not know. So all this, she saw you assaulting, yes, to see the wooden better. So all the explanation given by him is not exculpatory in nature. Okay, it all points, he doesn't deny the fact that, so this is his explanation here, his non-explanation is an added circumstantial evidence which corroborates the evidence of the prosecution. That's the only thing.
I leave it to Lordship.
Very difficult. I think that's hard. How do you assume that? Learn it. Amicus or no?
Amicus, no.
Not amicus.
I'm in amicus for last 26 years, Lordship.
Then amicus. You're for the appellant. Also had Miss A. Begum for respondent number for state.
State.
Miss R.B. Bora
Correspondent number 2.
for point number 2. After lengthy hearing. What have you got to say, madam?
Lordship, 2 and 3 is very reliable, Lordship.
But what about that? Who has said that in the cross said that did not witness the assault? Three.
Seen the assault, but they are at the house, Lordship. What are sisters there at the house? PWD 3 is saying that she heard the sound of beating, Lordship.
Okay.
And PW 2 is very much reliable. She said that while her mother saying that you are suffering from fever, you should not take the alcohol. Then he became angry and assaulted his mother.
Because for him, his medicine was alcohol.
Yes, Lordship. And he did not take to her, his mother to the hospital. Other persons taking her, but his own son.
He went to drink.
Yes, Lordship.
Okay, I will go. Hearing concluded, judgment.
Highly obliged, Lordship.
That it is not installed, but they could not demolish.
I'm legally legal.
Oh, Miss R.B. Bora, legal aid office. That's very important. 60.
Lordship, I was directed to obtain instruction from IG Prisons, my lord. In spite of my best effort, I could not obtain it. Lordship, may I pray personal appearance be called for?
Who?
IG Prisons, Assam.
Arey, this is your job. Why should
Lordship, I have written to them. My junior has written to them, written to her yesterday and day before. I have given repeated calls to her. She's not picking up the call. Jailer has submitted a report that is not up to date, my lord.
We'll give you one more chance. You just find.
That may be observed, my lord.
Okay, right. Miss B. Buyan, additional PP submits that no instructions have been forthcoming from the IG prison, despite communications being sent from the additional PP with regard to the remission of the appellant. The additional PP is given further time to obtain further instructions from the IG prison. This is the matter on after vacation.
Abdul Noor.
19.
Take
19?
The legal counsel, the insurance authorization.
Yes,
He's like the mother code.
Oh, she is for the victim.
you're for the victim.
Legal aid.
Who is for the appellant?
H.I. Chaudhary, A. Ahmed.
You're there, Mr. No.
Are you Chaudhary?
This is the rape of the.
WS 197.
This appeal is dismissed.
32. Criminal appeal date.
Ask me.
Party.
Dismissed. Item 3.
Jasmine, yes.
Dismissed.
No.
Yes, madam. Waiting only for you now.
May it please your lordship.
Lordship, this PIL has been filed challenging the,
So it has been done.
yes, your lordship, on the last occasion, after perusal of the inquiry report, your lordship, it has, where the inquiry report, it has stated that 18 people have attended the meeting. Your lordship, in the, after perusal of this inquiry report, where we can find that, there is no attendance, no name, and unknown people who has attended the.
That we don't know.
So lordship, from here, it is very hard to ascertain that whether the inquiry report has been properly conducted or not, your lordship. So lordship, today my prayer is, your lordship may freshly again direct the authorities to conduct the inquiry again, your lordship.
Where do you live, madam?
Lordship, as per my
Where does the petitioner live?
lordship, I am residing near that Azara only, your lordship.
Yeah.
The new proposed site has been.
Then is that shop going to be near? Is it within the permissible limit or
25.
is it beyond 75?
Lordship, as my claim that I am living under that 75-meter only, your lordship.
Where have you said that?
Lordship, in my averments.
Where?
Your lordship, may peruse page number 7, paragraph 9, your lordship.
Paragraph 9. Yes.
That the petitioner respectfully states that the resident live in a peaceful, predominantly residential neighborhood characterized by the presence of educational institution, residential colonies, and there is a BSF camp as well as there, your lordship.
Maybe BSF camp, let it be there. We're talking about you. How far away are you from the shop?
And so how many shops are there?
There's nothing here, madam, to show that you are affected or anyone is affected. If anyone is affected, they can always go. This is this is a PIL. PIL is, the objective of PIL is for those who are slightly needy,
Yes, your lordship.
not for all these things. So we reflect your name or your senior's name?
Lordship may reflect my senior name.
Senior's name. Are you sure?
Yes, your lordship.
Okay.
And
He's not here. Then
But he's not here. He'll say that, look, I'm not here, and they're still doing as if I'm here. Then
that would be better, your lordship.
what?
My senior name is reflected.
How do we?
you can say that
He was there.
part of
Yes,
the
yes,
last day.
huh.
And in continuation,
Yeah, right.
Madam has made the
I heard Ms. Zomanpui, learned counsel for the petition, M. Zomanpui, learned counsel for the petitioner, and Mr. R.R. Gogoi, learned counsel for the excise department. Today's hearing is in continuation of the hearing held on 5/12/25, where Mr. B.D. Kowal, learned senior counsel, had been assisted by Ms. M. Zomanpui, learned counsel for the petition. Okay, we'll pass the order, dismissed.
Obliged, Lordship.
Number 3.
Okay, Mr. Mr.
DK Mishra.
DK Mishra.
Sharma.
DK Sharma appears for his point number 3. Anything to say?
Obliged, Lordship.
Obliged. May this inquiry report be kept as a part of the record you made.
Okay.
Obliged.
Mr. Gugui, give a better copy for.
I'll do that, Lordship.
May I please your lordship? Lordship, in this matter, we are for respondent number 1. Lordship, we are being led by our senior Mr. K.N. Chaudhary. He is in legs in portal number 5. I humbly pray for timing, lordship.
Okay, let us do the next one.
Lordship.
No.
Yes. Mr. Bhuya.
My lord, my lord. My lord, the area is very narrow, my lord.
Correct.
My lord, because already there is a concurrent finding of the honorable division bench, my lord, of the concurrent bench. But my lord, here is a case wherein, my lord, if I can satisfy my lordships, my lord, that the amendment of the section 12A,
Correct.
which is the prime, my lord, concern in this issue, due to the amendment, the honorable division bench as well as the learned single judge has also held, my lord, that the UP basic education case is not applicable in the present case, my lord. So, my lord, if my lord just for a moment allows me, my lord, to produce the copy of the amendment, my lord, what it has exactly says, my lord, just for a moment, my lord. It's a amendment. Sorry. My lord, this is the amendment, my lord. If in the second page, my lord, section 12A is the concern, my lord, basing on relying on which both the judgment has been delivered, my lord. Section 12A says, my lord, for the purpose of maintaining the standards of education in schools, the council may, by regulation, determine the qualification of persons for being recruited as teachers in any pre-primary, primary, upper primary, secondary, senior secondary, or intermediate schools or colleges by whatever name called, established, run, aided, or recognized by the central government or a state government or a local or other authority. Now, my lord, if from my very limited understanding, my lord, 12A is relates to, my lord, for the purpose of recruitment and for the purpose of, my lord, fixing the standards of education, my lord. Now, my lord, where this 12A, my lord, has never says or has not bring the from the very basic, my lord, under section 2N of this, my lord, NCTE Act, wherein, my lord, the which categories of institutions are required to be, my lord, recognized by the NCT that has been held and clarified by the UP basic education case, my lord. So therefore, my lord, I beg to draw my lordship's attention, my lord, to the judgment of the UP basic. Only 2 paragraphs will, my lord, I will sum it up, my lord. And
what does the division bench?
Division bench has relied on this 12A, my lord. 12A, my lord.
Correct. That Muktaram Deka.
No, not Muktaram, my lord. Govind Sharma's case, my lord. Muktaram Deka is a long back judgment, my lord. That is of that the NCT is recognition, my lord. But here is a case wherein basically, my lord, this section 12A has been, my lord, repeated. My lord, I beg to draw in this judgments, my lord, paragraph 19 of this, my lord, judgment is a page, my lord, 438, my lord. Para 19, my lord.
Yes.
Page 438, my lord. It is the continuation page of SCC volume, my lord. At the bottom, my lord, para 19. May I read, my lord? A perusal of the NCTE Act shows that the Act was made to regulate the teachers' training system and the teachers' training institutions in the country. it may be mentioned that there are two types of educational institutions. Number one, ordinarily educational institutions like primary schools, high schools, intermediate colleges, and universities, my lord. And number two, teachers training institutes. The NCTE Act only deals with the second category of institution, that's the teachers training institutes. It has nothing to do with the ordinary educational institutions referred to above. Hence, the qualification for appointment as a teacher in the ordinary educational institutions like the primary schools cannot be prescribed under the NCTE Act, and the essential qualifications are prescribed by the local acts and rules in each state in Uttar Pradesh. The essential
copy type, manual type, copy.
Now, my lord, if we go by the definition of the NCTE, my lord, it has been two categories of institution, it has been, my lord, defined. That one category is the ordinary and the other category which come within the purview of, my lord, admittedly by the NCTE, their recognition is required, my lord. But here is a case, my lord, with all respect, my lord, what I humbly beg to submit. The CMJ University, my lord, is a university created under a private act by the state of Meghalaya under the CMJ University Act, by the, my lord, power conferred under the UGC regulation, my lord. So therefore, they have the UGC regulation, my lord, this university. So therefore, my lord, the university is itself conferring the degree, my lord. The vice chancellor himself is signing the certificates, my lord. So therefore, my lord,
Certificate can it sign?
my lord,
What certificate, what degrees?
degrees, my lord, sorry, my lord, the basic degree here is the B.Ed degree, my lord.
So so it can give B.Ed degrees.
Because, my lord, they are themselves, my lord, my lord, there are B.Ed training colleges in our state, my lord. These are being affiliated by the Guwahati University, my lord. There is a very nearby, there is a B.Ed degree college, my lord, and other parts of the state also.
B.Ed degree.
B.Ed degree, my lord.
Who is the authority that can give them permission?
My lord, the statutes give the permission. The
Statutes, okay, statutes made by whom?
statutes made by the assembly, my lord.
Assembly made, but with regard to which body? UGC or the?
No, my lord, the private university. No, my lord, the NCT is.
Push, that's the problem.
No, my lord, the NCT recognition is required for the colleges, my lord, but not for the university who himself or, my lord, my lord, taking up the courses and.
It is make up the university.
No, my lord, there are colleges like the B. Barua colleges or Arya Vidyapit colleges or the other B.Ed degree colleges, my lord. Those are required to be recognized or affiliated by an university. But when the university, there are certain departments, my lord, in the universities, like this is also the one of the B.Ed department in the CMJ University, my lord. My lord, we have annexed the certificates, my lord. It is 2012-13, my lord, like this. My lord. Yes, my lord, that is also an issue because, my lord, certificate. Yeah, yes. More file of yes. My lord, the appellant's degree is at page 115A, my lord. Page 115A is the type copy, my lord, and the original one issued by the university is at page 116, my lord.
70.
116, my lord. This one is, my lord, of having passed the university examination held in the year 2012, yes, my lord, 2012, with second division is awarded the degree of so and so and issued on, my lord. Date of issue is, my lord, 5/6/2017, my lord.
11/12 appeared in the exam.
My lord, my lord. My lord. My lord, I know, my lord, that there is always a doubt as regards the CMJ University, my lord. My lord.
Let us see this Mukta Ram Dekha judgment.
Yes, yes, my lord, we have also bring on this, my lord. ওখানে আছে নি? Citation. You want that or something?
Mughal the last idea for relevance. The total percent ideas.
This is the single bench order.
That is a single bench order. That has been relied on, my lord. That has been relied on by the Honorable Division Bench, my lord. In that case also, my lord, Muktaram Dekha.
Division bench.
But, my lord, there is a distinction because that is a degree, my lord, which has been discussed by this Honorable Court regarding, my lord, off campus, whether it can be done in a distance mode or not. But here is a degree we have obtained in campus, my lord, in campus mode.
But you have not been given the permission by the NCP.
That is correct, my lord. We, my lord, whatever, my lord, the NCT recognition which is required, my lord, that we do not have. The university is not required the NCT recognition, my lord. That is our stand, my lord. Had it been a college, my lord, what I respectfully beg to submit, my lord, our stand and our respectful submission before my lord is that, my lord, as this is a university, my lord, therefore there is no recognition from the NCT required. But had it been a college, my lord, then absolutely, my lord, NCT recognition is required under the definition, my lord. That is the distinction carved out by the Honorable Apex Court, my lord, in this UP basic education case, my lord. And the Honorable Rajasthan High Court has also, my lord, by relying the said judgment, my lord, in Singhania University case, my lord, exactly similar situation cropped up in the state of Rajasthan, my lord, has held. My lord? No, no, my lord, BEd, my lord. I have that judgment. If my lord, I'm traveling my lordship with that judgment also, my lord. দুটা কপি বনাব লাগিব এইটো আৰু আছে না if আছে নহ'ব এইটো তাতে যাব লাগিব কিন্তু উপায়টো নাই ন Milord, para 19, if we read with para, Milord, 22 is make more clear, Milord. B.Ed কথা ফোন education B.Ed from CN which has established already. Govind Sharma, I have annexed, my lord, in division bench, my lord, division bench to annex corner here, Govind Sharma. I think the order to assigning it to him. My lord can find it. Govind Sharma, read the fill number to play. Annex corner, but it has been referred here. Lord, rate appeal number 122 of 2024, Govind Sharma versus State of Assam. 122 of 2024, my lord. My lord, this is a, my lord, upheld the judgment of my lordships, my lord, delivered, my lord.
122.
Miles. So, my lord, my respectful submission, my lord, before my lordship is that para 22 of this UP basic education judgment, my lord, has categorically held that it may be mentioned that the word institution is defined in section 2E of the NCT Act.
Education judgment is of 2008.
That is correct, but it has not been overruled, my lord.
No, but then now the amendment.
Amendment, my lord, with all respect, my lord, amendment, if we go by the amendment, my lord.
We'll have to see.
Yes, my lord. If we go by the amendment, my lord, amendment has not amended this purview and the jurisdiction of the NCTA, my lord. It has not touched the jurisdiction of the NCT or not enhanced the NCT jurisdiction to
Yes, 2011. That has changed. Has changed. Where is that division by judgment? Oh, one page only you made. Get another one. No.
scope is very limited, my lord, I know. So, my lord, if by the amendment, my lord, by section 12A, if the NCT has also, my lord, regulates these universities, my lord, then regulates schools, my lord, that is correct, my lord. So that definition and the para 20. Yes, my lord, but our degree from the university, which has been again clarified by the honorable, my lord, the Rajasthan High Court, my lord, if my lord just for a moment can take up these two judgments, this judgment also, my lord. মার্ক করা আছে নাকি এটা? That is also, my lord, as regards the Singhania University, my lord, and that has also do not have the NCTE recognition. And this same issue cropped up before the Honorable Rajasthan High Court, my lord, and it has been decided, my lord, in 2017 judgment, my lord, 2018, my lord, after the amendment, my lord.
So what I can do? Yeah.
My lord. My lord.
In the meeting, they have taken their public published the newspaper. That recognition was given to Singhania University only for years, not for any teacher training.
My lord.
We come to the time.
My lord.
The bottom.
Yes, yes, my lord. The matter regarding the complaint against the Singhania University was considered by the committee. The committee decided to issue a public notice in the leading newspaper drawing attention of the public that B.Ed College, Pachibari, so and so, affiliated to the University of Rajasthan has been granted recognition by NCTE for B.Ed course and no recognition for any teacher training course has been granted by NCTE to the Singhania University. That is the case, my lord.
So B.Ed course recognition was given.
Recognition was given, my lord, to the colleges, my lord. Now those B.Ed colleges, my lord, who are imparting the B.Ed training or B.Ed course, they absolutely require the recognition, but not the university, my lord. Because university has already been recognized by the UGC, my lord. My lord, I may be wrong, my lord, subject to correction, what my respect. No, no. No, no. There are other colleges is there, my lord, but Singhania, my lord. No, maybe, my lord, that college may be, my lord, but here is a case, my lord, wherein the Singhania University has issued the certificates, my lord. And now, in our case, my lord, this is by the CMJ University, my lord. That is my only respectful submission for consideration, my lord, my lord.
In that case, then there is no requirement of NCT to give.
Exactly, my lord. NCT requirement that has been categorically, my
Then
lord.
that means then there can be no standard B.Ed course. And anyone can have their own course depending upon which university they are.
No, that is not my submission, my lord.
No, that is what is going to lead to.
My lord, that what is the what is the honorable apex, my lord, that is also a serious concern, my lord. Even my case is not being allowed, my lord, but I cannot submit or plead a case that what is a destruction to the society, my lord. But here is a case, my lord, wherein the university, the honorable apex court has held that as the university has been recognized by the UGC, my lord, so therefore a separate recognition from another statutory body is not required, my lord. That is the case, my lord.
Yes.
Lordship, for the post of headmaster, Lordship, there should be a valid B.Ed degree from a recognized university, Lordship. Lordship, from Muktaram Dekha, Lordship, judgment has been clearly stated, it has been clearly stated that a B.Ed degree obtained from CMJ University is not a valid one, Lordship. So in this case, Lordship, without having a valid degree, how can a person without having a valid degree for a post compete for the post of headmaster, Lordship? And it has been clearly stated in this judgment as well as in Govind Sharma, Lordship, that B.Ed degree obtained from CMJ University is not a valid one.
Muktaram's decision has not been put to challenge.
No.
No, Lordship.
That division bench judgment also has not been put to challenge.
No. Those petitioner has retired, only these two is surviving, my lord. There was a bunch of people.
Okay, right. Let me say council for the petitioners, appellants,
Right.
as well as Ms. R. Barwa for the
Respondents 1 and 2, Standing Council Education.
hearing.
My lord. Highly obliged.
Yeah, possible again. Photo कितना है?
My lord, I have made a small compilation, my lord. That I follow up here.
And then.
Photo picture.
The only thing that we hold the only university, all those, covered by the history. Because they were not. Yes. The approval of the NCT for imparting this behavior education, the degree should be given by.
Look, I have made a small compilation, my lord. Before that, can I have your lordship's kind attention to page 54, my lord, clause 5 of the advertisement, page 54. Yes.
Yes.
A minimum of 10 research publication in peer-reviewed or UGC listed journal and a minimum of 110 research score as per appendix 2 at table 2. My lord, there is no dispute that with effect from, my lord, 2024, this concept of UGC listed journal is no longer there. Now, my lord, all that I need to have is a 10 research publication in peer-reviewed journal. My lord, that we have given, my lord. I have also brought the original ones, my lord. All the one. All the original ones. All the. Now, my lord will kindly come to my compilation. Now, we found the other day I was given 0 marks. I'll explain that. My lord, please come to first, my lord, page 1 of the compilation. What is the difference between peer-reviewed journal and UGC care-listed journal? A peer-reviewed journal is a journal where articles are evaluated by experts in the field, while a UGC care-listed journal is a specific curated list of high-quality ethical journal maintained by India's University Grants Commission that are also peer-reviewed. The core difference was that UGC's additional layer of vetting to identify journal that met specific standard for ethical and quality publishing, particularly for Indian community. However, the UGC officially discontinued care list in late 2024 and now recommends that researchers use a set of suggestive parameters to identify quality peer-reviewed journal themselves. So, my lord, if your lordship kindly sees the definition, peer-reviewed, a journal that uses the process of peer review to evaluate manuscripts for quality and validity. And the care listed, a journal that was on UGC's official list, meaning it is both peer-reviewed and met the UGC's additional quality and ethical criteria. In other words, my lord, care listed journals are journal which has got the attachment of the University Grants Commission, some sort of vetting also, my lord. But peer review, as the term itself implies, is a peer review journal. And the requirement is either of that, my lord. Then if your lordship would kindly come to second page, my lord. Key takeaway, all journals on UGC list, care list were peer reviewed, but not all peer reviewed journals were on the list. UGC no longer maintains the care list. So primary standard for evaluating journal is the peer review process itself, along with other ethical and transparent criteria that were previously part of the UGC guideline. So, my lord, all my 10 journals, my lord, these are all peer reviewed, there is no dispute. Now, my lord will kindly come to page number 5, which is actually page 29 of the appeal memo, my lord. These are the research papers which I gave. Page 5 and 6. Then, my lord will kindly come to page number 13. This is the format, my lord, in which the assessment of the merit, or what we call it, evaluation, was made. Kindly come to, my lord, where the bone of contention is the third column, research and other publication. Has your lordship seen it? Yes. Maximum 5 bars.
Yes, please.
Page number 13. Research and other publication maximum 5 marks. Now kindly note me lord, 2.2 for each completed major research project. 1 point for each completed minor project. 2 point for each PhD and 1 point for each MPhil awarded under his or her guidance. 2 points each for research paper, article, book published in ISBN, ISSN. Now, my lord will kindly see this mention of ISBN and lordship will find in all my peer-reviewed, my lord, articles, research papers. Now, my lord, I do not possess major project or minor project, therefore that 2 mark was not given to me. Then, my lord, I do not have any guide, sorry, I did not guide any PhD or a MPhil scholar. So therefore, on that count also point was not given to me. But there is no dispute that I have the qualifying criteria of 10 research paper in my name. But what was not given to me, my lord, was that I should have been given 2 marks for the books. Nevertheless, my lord, even then I am above him. Now his grievance is
No, you are Dr.
Pratibha Patori. I have been 0 marks. I have been given 0 marks, my lord. Despite that, I got selected. My lord, that 10 research paper, peer-reviewed research paper, that's a qualifying criteria. That I have. That's why they have passed me. Why I am saying so, my lord? Lordship will kindly come to page 20 of this compilation. Page 20. Dear Dr. Patwari, this is in reference to your application for the post of Principal, Goreswar College, that the application submitted by you has been scrutinized and found eligible for appearing in the interview. You are therefore requested to appear before the interview board on 6th of April 23 at so. So my lord, screening committee has screened my everything. Having found me eligible, they have, my lord, invited me for the, what do you call it, my lord, interview.
No,
Then-
you see,
Yes.
you have been asked to appear on 6/4,
Yes.
and this letter is of 1/4, but this page 13 is of 6/4 also.
My lord, 6/4.
This is on date of interview. This
Same-
is okay. This is the interview. Okay.
Yes, interview. Now, my lord, we'll kindly see page 21 is the governing body's resolution, my lord. And page 22, where the eventual recommendations finds place. Pramod Medhi 1, Pratibha Patwari 2. Selection committee interviewed both candidates about their knowledge on different aspects of the college, including functioning of the college and duties and responsibilities of principal and his or her vision as a principal. The member of the selection committee found satisfaction in her performance, adopted so and so. The committee selected Dr. Pratibha Patwari for appointment as the post of principal, Goreswar College, based on performance in the interview held on 6/4/23. Then, my lord, my research papers are there. Then, my lord, will kindly come to the Government of Assam circular. How selection would be made, my lord? Page 33. Guideline for selection of principals in provincialized colleges of Assam. In cancellation of all previous government OMs, Government of Assam in Higher Education Department is pleased to notify the following guidelines for selection of principals. A master degree with at least 55% or an equivalent grade in a point scale whenever grading system is followed by a recognized university, a PhD degree in the concerned allied relevant discipline in the institution concerned with evidence of published work, associate professor, professor with a total experience of 15 years of teaching, etc., etc. A minimum score as stipulated in the academic performance indicator based on performance-based appraisal in Appendix 3 for direct recruitment of professors in colleges, etc., etc. And my lord, at page 38, 37, my lord, is the circular issued by the government of Assam whereby the vice chancellor of the affiliating university, my lord, was made the chairman of the selection committee, chairperson. So therefore, my lord, though I was not given 2 marks, yet I am selected, my lord. So I don't think it's a case where lordships should remand the matter now. The appeal as it stands, my lord, their only case is that he has given up that first point, that preference part he is not pressing. If he is not pressing the preference part, the only point which survives for consideration is what is the, my lord, credibility of this peer-reviewed journal. So these are before I have got all the originals also, my lord. In that being the position, my lord, the learned single judge is absolutely correct. Because their allegation in the writ petition from para 15 is they suspect some doubt about 4 of them. But the, my lord, university in their affidavit has clarified that. So in my humble submission, my lord, this writ appeal is without any substance, my lord. And it's a fact, my lord, in my original writ petition, when I said that his appointment is not correct because preference part cannot be given there, he never raised this point. Normally what happens, my lord, when I'm opposing somebody's appointment, then we take all plea the first possible opportunity. It was only, my lord, that too, not that now he is taking the stand in the writ appeal, that now he is relying on that committee. Most interestingly, my lord, the second committee, who has signed it, he is the academic registrar of the university and he issued the call letter to me, my lord. As a member of the scrutiny committee, he was also present. He having found that I am eligible in all respect, the interview call letter was issued. That is my humble submission.
My lord, coming to the my lord, document submitted by my learned friend. So far as that, my lord, 0 marks and 5 marks is concerned, my lord, your lordship will find at page 13 of that compilation my learned friend has just given, my lord. It's not that, my lord, the respondent number 1 has only got 0. The petitioner has also been given 0 in another heading, your lordship. Dr. Pramod Bedi, your lordship will see, my lord, column number 4.
Of his case.
Administration, he got, my lord, 0. And Dr. Pratibha Patri got 0 in, my lord, in respect to other things. So there is no, my lord, this is no dispute regarding this. Now, my lord, the question here is, this is regarding, my lord, after the scrutiny committee has found both the petitioner and the respondent, my lord, eligible, then only, my lord, this type of marks is concerned. My lord, we are not concerned with that. My submission before your lordship is that whether the screening committee was right in holding that the respondent is eligible. If your lordship kindly takes up my writ petition, my lord, the writ appeal, your lordship may kindly turn to page 235. This is a pleading, my lord, which was before the Honorable Single Judge. 235. I am reading the second paragraph. That the deponent further submits, this is my affidavit in reply to in my writ petition against their affidavit, my lord. The deponent further respectfully states that she has not enclosed the 10 research papers as submitted to the authorities in her affidavit in opposition. The 10 research papers submitted by her and obtained through RTI and the publication of the same in journals as claimed by her does not show any link with the publication in the journal except in respect of one article. Then your lordship, my lord, skip that. And your lordship may kindly read paragraph 8 at 237. This was the, my lord, pleading. This was not considered by the Honorable Single Judge. Paragraph 8, my lord. that with regard to the statements made in paragraph 9, the deponent respectfully states that along with his application form, he had submitted 20 research papers as reflected in part B of his application form. And out of these, the deponent annexed here with 10 research papers for the purpose of consideration of the Honorable Court, as the same reflect the details of the publication of journals such as journal name, year of publication, volume number, issue number, page number, and ISSN number, etc. Furthermore, the deponent further respectfully states that for the publication of articles in peer-reviewed journals, certain process has to be followed, like submission of articles, editorial assessment, invitation to the reviewers, conducting of reviews, journal essays and reviews, the decision of the journals. Furthermore, there is a guideline for finding out whether an article is peer-reviewed or not. The deponent further respectfully states that considering the publication of research articles in predatory journals and also to curb unethical practice leading to pay and publish trash culture, the UGC has published a public notice on academic integrity dated 14/6/2019 and 16/9/2019, wherein it has been inter alia mentioned that any publication in predatory dubious journals or presentation in predatory dubious conferences should not be considered for academic credit. That guidance was also, my lord, before the Honorable Single Judge. Your Lordship will kindly come to, my lord, page 433. These were all there before the Honorable Single Judge. Page 433. Thereafter, my lord, I'll show that, my lord, the papers published by the respondent are not peer-reviewed. These are all, my lord, pay and trash, except, my lord, one or two. Public notice on academic integrity. This has been issued by the UGC on 14 June 2019. May I read it, my lord?
Yes.
Increased incidence of compromised publication ethics and deteriorating academic integrity is a growing problem contaminating all domains of research. It has been observed that unethical, deceptive practices in publishing are leading to increased number of dubious predatory journals worldwide. It has been reported that in India, the percentage of research articles published in predatory journals is high, unethical practices and leading to pay and publish trash culture needs to be thwarted immediately. Research and innovation involve rigorous scientific effort in research of.
Why are you reading this?
I am reading this because, my lord, I want to show that the, my lord, papers that has been published by the my lord, purportedly published by the, my lord, the respondent number 1 are not, my lord, even peer reviewed. My lord, if your lordship permits me, my lord, I'll place her, my lord, the applications, the, my lord, research papers, and I'll show, my lord, how this has been published in, my lord, pay and trash journals.
So they are not peer reviewed. Now
They are not peer reviewed, my lord. If, my lord, she has submitted 10 papers.
how can you see that is the issue now? How can we determine whether it is peer reviewed or not?
My lord, that's why, my lord, if your lordship decides to send it to a committee, my lord, I have no objection that that is the end of the matter. And to, my lord, satisfy your lordship that if, out of the 10 papers, even one is, my lord, not peer reviewed or UGC peer journals published, then, my lord, her candidates are good.
But one thing is that you had a problem with only 4 of people, not all 10.
My lord, only 4 of the papers, but thereafter, my lord, on the basis, because, my lord, what happened? I was not aware of all this, my lord, until I filed an RTI application where, my lord, the authorities had given me the copies of her publications. Thereafter, I had charged that, my lord. Thereafter, I found that, my lord, those articles are not published in peer-reviewed journals. And, my lord, this is what will satisfy your lordship, my lord. If your lordship, I'll only refer to 2 pages. Because in the next page of the UGC guidelines, my lord, it has also been stated how these peer-reviewed journals are to be, my lord, assessed, assessed. Now, if your lordship takes up the first page, my lord. Yeah, yesterday, my lord, I had also shown, my lord, within 3 days, peer review has been done.
Sorry, you must have been here alone. I was not here yesterday. Yesterday I was not here.
I'm sorry, my lord, on the previous date. I'm sorry.
Okay, yes, yes.
Time flies, my lord.
Ah,
Time flies and sometimes we cannot keep track, my lord.
too many marriages.
Yes, that is one of the.
Yes, so my brother was saying too many briefs.
No, that is that's a problem with my learned friend, my lord, not me.
No, it's not a problem with me. I'm happy.
Okay, yes, where?
Being busy, I'm happy, to be honest.
Now, your lordship, if your lordship takes these pages, my lord, the last page first, your
And my
lordship.
workload has increased after his elevation to the bench. To be honest.
Now, if your lordship takes the fourth page, last page, this is the, my lord, first page of one of the articles of the, my lord, the respondent. Last page, your lordship will see, what does it say? This is the, my lord, article that has been the, my lord, relied upon by her, my lord, in her application and everywhere. Your lordship will kindly note at the top, 2020 IJCRT, volume number 8, issue number 9, September 2020, ISSN number 2302882. And at the bottom, your lordship.
Is this there?
Yes, these are there.
No, this one?
Yes, my lord, he has given all this.
No, this particular one he's talking about?
Yes.
In fact, I have got for all the 10 papers, but I am, my lord, showing only one now.
I just want to see that.
Yes, my lord. ISNN 2320, it is there. I've given the original, I can give the originals also. All are there.
Now, your lordship will kindly see the bottom, my lord. The page number is given 4406.
Correct.
Now, if your lordship kindly comes to the first page, this is the, my lord, the journal, the International Journal of Creative Research, Thoughts, IGCRT, ISSN 23202882, the numbers, my lord, tally. Then journal, volume number 8, issue number 9. Then, my lord, I give the index page. If that book is there, your lordship may find it. My lord, your lordship may peruse there. The index, my lord, I have, because every journal has its index. For the time being,
No, that particular book. Okay, this is the one.
This is the one, my lord.
This is the one.
Yes.
Okay.
so there may be an index, my lord.
Oh, this is different.
I have downloaded it from the, my lord, their site.
Issue 9. United Journal of Trade. Okay, so 382, huh? Yes.
There, my lord, your lordship will find the index, my lord.
Index, yes, there was index.
Index page number. Your lordship may
Wait.
kindly check the page number, my lord. I have downloaded it. I didn't have that book. I have downloaded it from the internet. Now,
No, there is no index.
complete check with this. There has to be an index. I have downloaded the complete one. I have only given the extract, my lord. Your lordship may also peruse this. The complete index I have given here. Downloaded, my lord. The reason maybe, my lord. Maybe the reason is that in the, my lord, index on the, in the, my lord, in the website, they have got, my lord.
Just a minute. You want to meet the person? Oh, no, okay. Okay. What the- Everything should be. No delusion. Ignore the. Itu dah complete set 9 ada. Kalau 9 complete set. My lord, this is what we found in the, my lord, we have downloaded from the, my lord, website, where there is a big index. I have only given the, my lord, relevant piece. September 2020. September 2020. This is September 2020.
Willard, I understand, Willard, that this index part would be in the volume, not on the particular issue. And all these things were screened by the screening committee. Those are all experts, including Vice Chancellor of the Borderland University.
No, that's what it
Yes.
appears to be.
But it, Willard,
No, my
I
lord,
think
what
that
I
is
don't
in-
know, what I am trying to show, my lord, at page, my lord,
4406.
4406, my lord, there is another article. If your lordship will see, my lord. My lord. No, my lord, the set I have given your lordship, my lord.
That index.
Single piece. Yes, my lord.
557.
557 is,
West side workspace. 440.
440 to 440.
that's a different article. That's a different research paper.
The 4406 to my head.
Ravika.
That's a different article.
No, it's the same one. The index. And it express at workplace.
It's same.
Ravika.
The same article.
My lord, the,
Now, Mr. Chokha, the problem here is, the next article given is 558.
my lord, managing stress at workplace by Ravi Kant.
No, it is there.
It is that.
It is there.
My lord,
I'm just seeing the earlier.
my lord,
So it ends at 54405.
4405,
The
yes,
respondent's article starts at 4406.
my lord.
Now you see here. 557, 558, the page numbers don't match. 4400, 4405. The next one is 4416, 442.
It should have been 06.
What happened to 062?
No, no.
415.
No, it should have been 06. They made it by mistake 16.
No, Willard.
One question is, my lord, why it is not there in the, my lord,
Let's
index?
say is this one. It's study this the one. No, that's different. They missed out. Oh.
That article is not there in the index, my lord. That is,
Pages are also.
yes, my lord. That's the, my lord, reason. That is where,
This is the index.
my lord,
Index will contain what is there.
it should contain everything, my lord. That is,
But index is up.
Index 4406 onwards.
my lord.
Till 44015.
Yes.
It is missing.
That has been kept, my lord, for, my lord, the cash for publication.
For?
Cash for publication, my lord. That's why, my lord, those pages are missing.
That is
Otherwise, how can it be, my lord, the pages can be missing in index? And why that book also does not, my lord,
Mistake.
no, that is, my lord, in respect,
Typographical and
that is in respect of other papers also, my lord.
I don't think we will be able to go into all these issues.
That's why, my lord, my prayer is, my lord, very simple, my lord, your lordship.
Well, I think we'll send it to.
If your lordship
Lord,
sends, I will
before
not make any
no,
further
no,
submission.
No, merely because he has come up with some half-cooked food.
No,
Lordship will
not half
do
cooked,
that.
my lord, I'll show.
Then come up
No,
with
then compare, my
come up with an index which discloses each and every page.
It does not, my lord, it's a
Question
fake,
itself is begging an answer.
it's a fake organization, my lord.
On a court of law like this.
We can do is we can constitute a committee, a very fair committee. I know you have got apprehensions that it might not be.
No, what I'm saying is, my lord, because he's so powerful, despite his appointment being set aside, he continues to be principal. Your lordship passed the interim order only the other day.
Yes.
In between, my lord, more than almost 2 months, he was the principal. Because kindly see, my lord, a person was not even, selected, he was sought to be appointed. Because of the intervention of this court, my lord, his appointment was set aside. Now he's still managing. Your lordship is
No,
not the-
sir, not a question of managing, I am arguing on law, my lord.
That these small things, these things regarding
My lord,
this.
my lord, if I've
Your lordship
understood
will
the
see
legal
my
position
publication.
correctly, normally, my lord, these are job of the expert. If your lordship finds glaring mistakes, yes, of course, lordship will say. If
I
somebody
am
says
saying the glaring
black
mistake.
and white, then you will say. But if it is slightly darker black or a light, or that lordship will not.
Your
That is
lordship
not the
will-
area for the scope of judicial review.
Your lordship will see, my lord, my publications, I am giving an instance, my lord, how everything is given in the first page itself, my lord. If your lordship sees the file, ek na copy diya then.
Look, how
First page, my lord, everything is written, my lord. The website, dates, everything is there, my lord, copyrights. And then, my lord, when the article is received, when it is, my lord.
Nuclear evaluation and microbiome activity of observed sequence was also.
Okay.
Right. So Delhi Sultanate Chaudhary, go one.
Your lordship is referring, my lord.
This schedule site, I feel.
4-1.
Page 4-2.
Page 4.
The fifth page. It is the fifth page.
The first page of all the.
Yes, first page. I have got the shape, see?
Next, same journal, International Journal for Research and Analytical Review.
Click the website.
Four 21. FI page the same.
What is the?
আমি তো কমপ্লিট সেট টু করব দিছি এই কুইজের অ্যাপ্লিকেশন দিছি
The principle of the photo. It should be at least 4 experts. No. 3 to 4. 3 to 4 experts. Good. They have to be. With that paper.
If your lordship sees, my lord, one instance I have given my lord paper publications, everything is, my lord, clearly given, my lord.
Look, we don't know. We are not experts in that area. We are
That's why, my lord.
totally floundering in that area.
My lord, that is how they, my lord, they interpolate. Otherwise, how can they interpolate?
Thinking that maybe we will ask the a fair body, say maybe Cotton University or something, to constitute a committee, or who will be a fair?
Asile. Milord, I'm told by my learned friend, Milord, I think somebody from Cotton University was in that second committee.
So Cotton
Okay.
University should not be there. Cotton
I'm
University.
saying that,
Can you give
that
us,
person should not
you
be.
give us a suggestion? You give, suggest,
Yes, yes.
you make a suggestion.
Milord,
We want around 3-4 experts to be there.
I think that let it be, the earlier scrutiny committee was headed by Milord, the chairman, vice chancellor of the Borland. I don't know whether the same person is there or not, I don't know.
Let it be
So
some-
let it be headed by the Borland chairman, and Lordship will nominate two member.
My,
Maybe 3-4 of them, they will be fair, I think.
my prayer would be, my lord, let it be some other university or IIT, my lord.
I don't know. IIT?
IIT
No,
can be
if
done.
your lordship is having some doubt about the fairness of the
No, we-
exercise done by the first committee, then of course it is lordship's prerogative, there I'll not come. First of all,
You see, the thing is that there has been
No,
a.
my lord, my learned friend has raised a perspective that itself is begging an answer because that index page is not there. When the question itself is begging an answer, why should one undertake to answer that question?
That is how the-
These are issues beyond us.
It is subject
That's
case,
the problem. Yeah. You see, we don't want any of the first and second actually to be there, because the second one contradicts the first one. So, if you all both agree, we can have that vice chancellor of that Bodoland.
Yes,
If
I
you all
agree.
My lord, my submission will be, my lord, your lordship has seen the vice chancellor was there in the second selection committee, so he'd like to, my lord, support that. That therefore, my lord,
No,
my
no,
prayer
there's
would be-
nothing like it.
because-
No, my lord, under the government rules framed by the government, it is the vice chancellor who is the chairman of the selection committee.
Yes, I think the vice chancellor.
Yes, yes.
Will head
My
the.
lord, my humble
the
submission is lordship should not interfere with any of the position. Let a report be called for, then a lordship will pass it on. From the authority regarding the
The learned
both,
was suggesting-
my lord, both, not only me.
Oh, yes. I am ready, my lord.
But give us the names.
Lordship, I have collected 3 names.
First,
One is.
tell everyone, let it be fair, let it be fair.
He's academic registrar of Watt University. One, Mr. Rishikesh Borua, he's a principal, KCS Commerce College. And was Manoj Mohanto, principal, Pragjyotis College. They are.
Subject expert.
They are not-
No, subject
Here,
expert is not
Dr.
necessary.
No, I don't
Subject
think so.
expert is not
Subject
necessary.
experts.
No, in the
Process, whether it's here.
the selection in the guideline, selection process, I think the subject experts are necessary, some experts are necessary. The selection.
No.
Professor. Let us just, otherwise we might be making a mistake.
Number 33, Miller, of that compilation. At page 34, a minimum of 10 research publication in peer review are listed.
Then,
There is a body to examine this.
Body, my lord, the original one, my lord.
the screening committee and the.
No, it is a committee.
There is no guidelines regarding, my lord, so far as I know, my lord.
Millard, in fact, there is a committee called Millard IQAC, Internal Quality Assurance Cell.
Border University.
Borland, every university has that, Millard. In fact, in my case, Millard, that committee has already, in fact, initially both of were appellant and the respondent both are clear. Internal Quality Assurance Cell. Let the Borland University committee do it, Millard.
My lord,
They call it
that committee
IQAC.
has made that, my lord, still earlier, my lord, screening.
Hinko ki kotha আছে?
The same committee, my lord, is sending back to, my
Not the
lord,
vice chancellor.
from Caesar to Caesar's wife.
Okay, you give us the name.
Lordship.
But no one from.
Dr. Rishikesh Borua. The principal, KCS Commerce.
No one from that Bodoland area, huh?
Should maybe outside borrowing.
This. There,
Dr. Rajiv Gandhi,
you give us the name.
Academic Registrar of Art University. One Manoj Mohanto, Principal Faculty.
মনোজ মোহন তো কেনে ওকে ভাল ভাল ওকে ওই এখানেই মিলাম
My lord,
Three names.
my lord, I have got some reservation about the, my lord, the committee being headed by the, my lord, vice chancellor was.
We're not going to put.
Then, my lord, may I suggest another name along with that, my lord, someone, the registrar from the IIT, my. IIT
No, well, I think these three names are good enough, Miller.
Okay. Has to be a head. Who should be head?
Probably Rajiv Gandhi could be the head. Academic Registrar of Art University to display.
Senior merchant.
Sounds so much.
No, brother, it's okay. I think it's okay. Okay, give us the name.
My only humble submission is, Miller, let the first committee give a call, then your lordship will take a final.
I have no reason, no objection to that, man.
Because he will continue in the meantime. By the college.
Also, the day we look. Boroma College, we directed by the day.
Who will, which one?
Director on a sales force.
Gorestar College. Yes.
PTC.
Yes.
Director PTC will produce the entire records.
Well, they did not go.
And who will give remuneration to these three persons? VTC, when will they pay? That is the.
BTC, Miller. Because now Hagrama Mohillar is there, he is a very fair person.
And a lot of funders.
And do we have to give the amount of remuneration to be paid? Or
I
what?
think they have their own set of fees, Miller. Fee structure is there for undertaking such exercises. I think that university normally makes the payment, huh? Sanction করতে 3 বছর লাগে।
Okay, we'll let them give the report within a month.
Opening Miller, it'll more than 1 month.
Holidays, your lordship.
Today is 8th.
বিহুর আগতে হবে দিয়া।
Today is 8th.
Let it be on 9th of January, Miller.
No, 9th, no, not possible. Maybe, huh? 17th. 9th because I might not be here on.
Okay.
19th. How, 19th?
After Bihu.
This is a matter on 19th. I'll give the order.
Yes.
They just give the name.
Fine.
I think you should take all this back. Because
Yes.
it's coming too thick for us.
Lordship, registry shall intimate them, my lord. Registry will
Yeah.
to the person concerned, to us.
Yes, everyone, all of you all.
My lord, one more sentence, my lord. Interim to continue.
Interim order to continue till the next day. BTC will produce the documents. The remuneration will be paid by the BTC authorities as per their norms.
That may be quoted, your lordship. There may not be any norms.
And in the event they have no norms, they will be paid how much?
Per city, per person.
10,000 each, Miller.
Today.
Not in total, but three.
It's not too less.
No, Miller, 10,000 per head. Miller.
I know, but isn't it
I'll give
2,000?
it to your lordship. 15 or 20.
20,000 equal. How they will make norms?